Highly obliged. May I please allow? Actually, I beg to mention item number 74 of the supplementary list. I'm just praying for some accommodation for today only. Lordship. It will be taken out Wednesday, Lordship, or Friday. I've taken the consent of the other side, Lordship. I'm for the respondent. On Wednesday or Friday, Lordship. After next week, Lordship, there is some agreement next week. Twenty-eight. 28. Obliged, Lordship.
May it please the Lordship. With the consent of the other side, I beg to mention item number 2 and 35, Lordship.
You wait, item number 35.
35. Lordship, my senior Mr. Espidas, due to some personal difficulty, he could not come, and also given his letter of absence, Lordship.
Right, 35.
May it please your Lordship. Lordship, I beg to mention item number 41, my lord. In this case, the company has gone into liquidation, my lord. Liquidator has been appointed, my lord. So with the consent of the other side, we pay for 4 weeks time, my lord, in the matter.
Your matter?
41, my lord.
Or for the petitioner.
Therefore, the petitioner, my lord, we have not filed our wakalatnama yet, my lord. We will file our wakalatnama for the liquidator, my lord. We have received the file yesterday only.
Liquidator.
Lord, the company has gone into liquidation.
For the petitioner.
My lord, we will be representing the petitioner, my lord.
The
We have,
NCL.
Lord.
Item. Resolution professional.
Lord. I am obliged.
May I please, Lordship, I wish to mention item number 39, Lordship. In this case, Lordship, I am be allowed to 3 weeks time to file affidavit in reply against the affidavit opposition filed by the respondent.
Lordship, may I pray for a date, Lordship? Stay order is there, Lordship. Lordship.
Plus, interim order may be
Obliged.
May I please your Lordship? Your Lordship, I beg to mention item number 76 of the supplementary. Your Lordship, my senior is out of session, so your Lordship, kindly.
My lord, in this case, urgency is there, my lord. We have filed an IA application for vacating of this stay, my lord. It's a disciplinary proceeding matter. They have obtained this stay, my lord, because on the.
Did it be on first?
Kindly accommodate 1 week.
1 week first. First of April.
First of April, okay. I leave. One interim order is there, your Lordship.
My lord,
1st of April.
1st of April is okay, my lord, but if it can be taken up on 25th, my lord, urgency is there.
What difference does it make between 25th and 1st?
Okay, my lord.
They are asking for
My lord, okay, my lord. No further adjournment may be given, my lord. That
counsel for the
Interim order is there, Lord.
petitioner submits. A prayer is made on behalf of the counsel for the petitioner that she is out of station, and adjournment is sought for. Mr. B.K. Singh, learned counsel representing the F3I, submits that there is an urgency in the matter, and therefore the matter be listed on a fixed date. Accordingly, as agreed to by the counsel for the parties, matters then referred for today to be listed again on 1st of April.
Lord,
Interim order passed earlier will continue till the next date fixed.
Deeply
It is made clear that an attempt will be made to dispose of the petition on the next date fixed.
Deeply obliged.
oblige, my lord.
May I please, your Lordship? With the concern of other side, I beg to mention item number 45. Lordship, the conducting counsel, Mr. D. Bora, is out of station. It may be taken up on next week.
45, the request made on behalf of the counsel for the petitioner, matters then referred to be listed after 2 weeks.
Obliged.
Yes.
May it please your lordship. My lord, this similar matters are pending and listed tomorrow. And it may be tagged along with writ petition number
No, but, it
5067.
is difficult to take it, my lord. Facts is different, my lord. That's
But,
why
the-
it may be, my lord.
See,
Notice will have to be issued here.
Yes.
This is a fresh matter.
Lordship, it may be tagged with that. And then individually writ petitions are taken up
So
tomorrow.
these matters are fixed by whom? Before which court?
Bench before court number 4, lordship.
Parted better.
Yes, tomorrow those matters are there, lordship.
Facts are different, my lord. That's why take
All
it
the
different, my
cases
lord.
facts are
We'll have to
different.
reply it, my lord, again and again, new case. That's why notice may issue, my lord.
But without giving them an opportunity of hearing what disposal are you expecting? This is a fresh matter.
Yes, lordship.
Whatever you stated, they're entitled to some reply.
Yes,
some
lordship. Yes, lordship.
Even though it is not maintainable because, my lord, he was minor. He was 9 years old when his father died. And, my lord, available, my lord,
We
so
can
many.
issue a notice if you want.
Yes, lordship. Issue notice.
Heard Ms. D. DC Sutia, the counsel representing all the respondent, represents all the respondent. Issue notice, refundable 3 weeks. Since Mr. Sutia represents all the respondent, which is the waive, extra copies be furnished within a period of 1 week from today. It is submitted that the all right, on the next date you make a mention.
Yes, lordship.
See,
Next day.
list according.
All right, yes. Extra copy,
Deeply.
yes, copy.
And appears for the petitioner on hold. Office note reflects that the previous Lozima courts had ordered for undertaking fresh steps for issuance of notice on respondent 5, but no steps have been taken on respondent 5. So the order passed by the earlier court, last order passed by this court was on 23/7/2021, permitting the petitioner to take steps, although none had represented the petitioner. So today also when the matter is called up, none represents the petitioner. Purely for the ends of justice, matter stands deferred to be listed after 1 week. In the event the steps as directed are not undertaken, court may pass appropriate orders on the next 8 weeks.
Lordship, this is the matter of petitioner was discharged from service. Petitioner was discharged from service on account of poor reading entry, my lord. In the last occasion, we have taken the time for file the affidavit reply, my lord. But we could not file, my lord, because the petitioner was not in our communication. And otherwise, this is not necessary, my lord, because the Honorable Supreme Court has already decided this matter. To let this matter be fixed in admission for me.
What is the issue? What has Supreme Court decided?
On the poor ending entry, my lord.
On the
4 rating entry matters.
Yes, madam.
My lord, I didn't get the copy of the Supreme Court, sir. My lord, kindly hear the matter.
Which judgment are you referring to?
Amrinder Kumar Pandey, my lord, but I have not in my hand today.
It is submitted by the counsel for the petitioner that on earlier occasions, they had sought for opportunity to file affidavit in reply to the affidavit in opposition filed by the petitioner by the respondent. Stop. However, it is now submitted that
Petition to
the
the-
affidavit in reply would not be necessary to be filed in view of the judgments of the apex court, which squarely covers the issues raised in the present writ petition. So, the counsel for the petitioner, however, submits that he does not have the relevant copies of the relevant judgment available with him today. Raised for another date. Place the same before the court. Accordingly. Let the matter be listed again on. 3rd of April.
Wait, please. Last occasion, my lord, the private respondent has entered appearance,
Private respondent.
has entered appearance, my lord.
Ah.
And so for their prayer was such to file objection.
Office note, my lord, may kindly please office note 4/3/2025, my lord.
You have to take steps for paper publication. You have taken steps
So for my lord, private respondent is concerned, last occasion they appeared, right?
for respondents 6, 7, 8.
Yes. 6, 7, 8. They entered appearance. They were to file affidavit, my lord. Perhaps my lord, name has not often not been shown. The cost is.
No, but the office note says that they are not represented. Their wakalat is not available.
My lord,
Yes.
that is.
Last occasion, what happened, my lord? One learned sister was appeared, entered appearance for record number 6, 7, and 8. Perhaps in the last order, my lord, that has been recorded. And so far, their appearance is concerned.
So we recorded it, but we directed the office to verify the wakalat nama
Yes.
stated to have been filed.
On that last occasion, my lord, Wakalat number was not filed.
That's
That was
right.
supposed to be filed during that period, my lord.
It is not filed. That's
Then
what
I have to take instructions from my learned sister
Hmm.
whether she will appear or not. If she will not appear, my lord, I have to, my lord, give a paper publication.
So we permit you to take publication for the last order.
Ma'am.
Meanwhile, if you can get
Yes, yes,
instructions
yes,
from
that-
whichever
that-
council,
Yes, ma'am.
you come and apprise the court accordingly.
Yes, sir. Yes.
But we are making it clear that you will have to take steps for paper publication. Heard Mr. M.K. Sharma, counsel for the petitioner. And Mr. B. Sharma for
Respondent number 1 and 4, my lord.
respondents 1 and 4.
I'm for respondent number 2, 3, and 5, my.
Mr. Kumar,
Mike.
yes for
2, 3, and 5.
respondents 2, 3, and 5. Stop. As per the last order dated 4/3/2024, MS R. Kolita, who had learned counsel had entered appearances on behalf of respondents 6, 7, 8. Stop. This court, however, directed the office to verify and connect the wakalatnama stated to have been filed by the learned counsel appearing on behalf of respondents 6, 7, 8. Stop. Pursuant to the same direction, Office Note 4/3/2025. In Office Note 4/3/2025, registry has made made the remarks that the wakalatnama has not been received on behalf of respondent 6, 7, and 8. So, under such circumstances, the counsel for the petitioner submits that he be permitted to take steps by paper publication on respondent 6, 7, and 8. He prays for 4 weeks' time. Prayer made is not objected to by the counsel for the respondent. List again after 4 weeks.
Obliged.
Hey, please your lordship. As the same matter is pending before the division bench, lordship. We have challenged the rule, lordship, their rule. Now, so
When
lordship, it is in the hearing stage, lordship. I mean, respondent to. in the
Matter
division
is
bench.
listed today.
No, it is in the hearing list, lordship. So this matter may be,
Yes. It is submitted at the bar that the issue raised in the writ petition is also pending for a division bench. And the matter is likely to be taken up for hearing by the division bench. Counsel, therefore, counsel for the parties therefore submit the matter be deferred to be listed after the listed after some time. In view of the submissions made by the counsel for the parties, matter be deferred to be listed after 8 weeks.
matter, lord.
May I please, your lordship? My lord, kindly the order dated 21/9/2023, my lord. On that day, it was submitted that instruction has already been received.
Yes, Lordship, instruction received, we prepared the affidavit, Lordship, it is sent for vetting, and after vetting, Lordship, it was notarized, but we received some defective notarization affidavit, Lordship, therefore kindly fix the matter after a week, Lordship, I will file the affidavit within that. The 24th.
On what grounds are you challenging the selection?
Which I is not prepared, my lord.
So proud.
Matter be listed after a week,
Lordship.
as it is submitted by the council, by the Learned Government Council. The affidavit can be filed within a week's time.
Lordship.
We are recording your submission.
Yes, Lordship, we
Mr.
have,
J.
we
Khan
have,
appears for the petitioner.
yes,
List after a week.
Lordship.
Obliged.
None appears for the petitioner. Yes, Mr. Gupta,
My lord, I am appearing in item 9.
anything to submit?
My lord, they have filed an amendment application, my lord, and I have seen the orders, my lord, the service upon respondent number 7 has been complete, but other respondents, my lord, it is not complete as per the.
None appears for the petitioner on call, Mr. H. Gupta. Appears for the respondent. This is an item number 9.
My lord.
Who is appearing in 8?
8, my lord, The other CGC is there, my lord. Okay.
Report the name of Mr.
My lord,
8 and 9.
my lord.
Matter passed over to be listed next.
No.
Yes.
May it please your lordship. Lordship, on the last occasion, lordship, the petitioner we were directed to take steps, necessary steps on the respondent number 4, lordship. Lordship, due to the address, the change in the address of the respondent number 4, we were unable to take the proper steps. But on last date of 6/9/1, we have taken fresh steps against the respondent number 4 in the new address, lordship.
In terms of the earlier court's order, fresh steps were taken on 9/1/2025. So, however, service of notice is not yet complete. Matter be listed after 3 weeks. Mr.
D. Das, lordship.
D. Das appeared for the
Lordship, interim is there, lordship.
matter be listed again on 9th of April. Interim order passed earlier. We'll continue till the next 8 weeks.
Lordship, respondent number 8 and 9, they have also filed a reply in opposition. Lordship, we would like to file a reply, affidavit in reply, lordship.
Petitioner is permitted to file reply affidavit to the affidavits filed by
8 and 9, lordship.
the respondents 8 and 9.
Much obliged.
May it please your lordship. In terms of your lordship's last order, lordship, they were required to file their objections. They haven't filed it. And lordship, they have requested another copy in meanwhile. So we'll serve them a copy and matter will be listed thereafter.
As per last order, the respondents were permitted to file objection. However, the same has not been filed. Matter will be listed after 2 weeks, enabling them to file their objection. Meantime.
Obliged, lordship.
This is a matter regarding, my lord, person with disability. Now, my lord, he was selected, my lord, in the year.
What is the IA for?
Well, IA was with regard to, my lord, they have, my lord, made a claim that there are no vacancies. So, my lord, I filed an application, my lord, under the RTI Act, and they said there is one vacancy for orthopedically handicapped, my lord. The petitioner belongs to that category, my lord. So that's why, my lord, I had filed this IA.
Why
Actually,
is
my lord,
it for orders today?
actually,
We
praying
have
for,
filed
my lord,
affidavit, my lord, the petitioner, what is the facts? First of all, he narrated to facts, my lord. What he say, he has made contradictory statement. Once he said he 2005, 2004, he was selected. And next he says 2008, 2009 selected. But actually, he is not selected. Candidate. Our affidavit, lordship, is here. The question of, my lord, any.
You are not filing rejoinder affidavit.
my lord, rejoinder, I would like to file, my lord. Because, my lord, he has made some statements, my lord, which are totally incorrect, my lord. A different person's, my lord, name has been, my lord, included in my case, my lord.
You were given time 3 years back.
True, my lord, but then, my lord, there's some difficulty, my lord, my lord,
3 years back, you were given
true,
time
true,
to
my
file
lord, true,
rejoinder.
my lord, true, my lord, that's true, my lord.
Good.
Somehow it, my lord, missed out. my
So
lord.
far, our affidavit is concerned, my lord, there is no case, my lord, at all.
My lord, they have, my lord, tagged,
No
my lord,
case, my lord.
tagged two selections together, my lord. In
No,
fact, this
this matter
affidavit is
be-
totally wrong, my lord.
Listed for admission on 8th of April.
My lord, in the minute.
The petitioner is permitted to file rejoinder if so advised in the meantime.
Obliged.
Mr. T.C. Sutia appears for all the respondents.
All orders.
In these two matters, my lord, I have been requested to appear on behalf of ONGC. There's a contempt tagged with a repetition. But there are very voluminous facts involved. We need some time to file our response in both the matters. The Lordship will allow us 4 weeks' time.
Mr. Chaudhary,
Very voluminous facts. We'll need some time to get completing instruction.
Mr. Chaudhary doesn't object, Mr. Chaudhary.
I
He has always been.
I don't object anyone.
Right, heard Mr. P. Chaudhary, learned counsel for the petitioner, and Mr. I. Chaudhary,
4
the
weeks.
senior counsel, assisted by Mr. B. Chaudhary, submits that they would like to complete their instructions, like to complete his instructions in the matter. And you'd like to file some affidavit also.
Affidavit.
At an affidavit, appraised for 4 weeks' time. Prayer made is not objected to by the counsel to the petitioner. Let the matter be listed.
Your lordship may have it 28th of April.
Can, you can put 28th. 28th of April. Right. Is there a contempt petition also?
There's a contempt also.
This is the contempt.
Same order may be passed in both the cases.
There is a writ petition also. So you are filing your objections
In both.
Same order.
Deeply of it.
Right.
Last occasion, all the parties have appeared, my lord. They are supposed to file affidavit.
May I please, Lordship, I am appearing for respondent. Mr. B. Deory appears for respondent number 3, that is Director of Pension, Lordship. He is not available today. He asked me to place.
Where is the order?
Page 11. Operative part. Page 15. There is stipendary, sir, and their cases are covered. One, two. Notice for what? Those employee APR also.
Now, what is the meaning of this instruction?
Lordship,
Their cases were to be considered in terms of Purnima Hore.
yes, Lordship. And as per the instruction, Lordship, that has, they are teachers, Lordship, and the proposal has to come from the education department. Here, my learned friend, they have made respondent number 1 and 2 a party who are authorities in the education department, Lordship. So, as per, according to the Director of Pension, since they have not received the proposal yet, the finalization of the pension as well as the opening of the GPF account cannot be done from the by the Director of Pension, Lordship.
Who has to furnish it?
Lordship, respondent number 1 and 2, Lordship. The authorities in the education.
Who is for the education, elementary education?
Notice.
Last occasion, R. Mojumdar appeared.
Elementary education, who's there? Mr. R. Muzumdar.
Lordship, he had appeared on
R. Muzumdar. Heard Mr. N. Sharma for the petitioner, Mr. H. Alia appearing for the finance.
For respondent number 4, Lordship.
After some time, he may come. R. Mojumdar, I have already sent me.
What instructions will he carry?
Regarding
We
the
don't find any pleadings there.
last occasion, he said that some instruction has received. But
All right, you call him then. We'll take it up. At 2 p.m.
Counsel in Bremen, Lordship, father-in-law passed away yesterday night.
Who's?
As Dr. Olot.
They are supposed to file the affidavit in
They were supposed to, but he's in bereavement.
Well,
Yes.
It is submitted. Mr. R. Islam appears as legal aid counsel. Mr. Your name?
SS Bora.
S.S. Bora appears on behalf of the respondent and submits that the arguing counsel has Dr. is in bereavement. He therefore submits that
2 weeks.
the matter be deferred to be listed up 2 weeks. Considering the prayer made that Mr. Dotto is in bereavement, matter stands deferred to be listed after 2 weeks on a date to be fixed by the registry.
Well, the matter may come up for admission hearing, since they have already entered their appearance.
Be listed for admission.
The date may be, well,
Date will be fixed by the registry.
Lordship, may kindly pass over this matter for time being?
In this matter, I filed my
On
affidavit
court
only
number
today.
one.
Affidavit only today. I have some copy to Mr. Mazumdar also.
So,
Taken them up in the next week.
yes,
For time being?
he's praying for a week's time.
Okay.
MS so-and-so appears for the petitioner and Mr. heir MR Odigari. You appeared in 2024.
My lord, yes.
Then
Well, what happened
why did
in
you
this
say
case,
you recently appeared?
my lord, what happened in this case, my lord? The Paraba's comment was furnished to me on 2nd of December 2024, my lord. Due to some reasons, my lord, I could not file it.
No,
It
don't
escaped my attention, my lord.
make, but then don't say that you have been recently engaged.
No.
You mentioned
What I
that
said was, my lord, I have filed my affidavit only today.
affidavit.
Yes, ma'am.
You have filed the affidavit.
Yes, only today, ma'am.
Okay. In the writ petition.
No, my lord, in the I 3379.
In the
The
I.
yes, no, the I is for seeking condemnation of delay. In filing the.
So you are
implement
objecting.
petition.
You filed your objections in the I.
My lord.
Okay, Mr. MR Odikari, learned CGC submits that the objections to the I has been filed today. Stop. Para. Since the objections by the respondents have been stated to be filed today, the same are not connected to the case record. Matter be listed after 1 week. Stop registry to connect the objections stated to have been filed by the respondents.
All right, my lord.
List up next week.
All right.
My lord, there is a delay of 279 days in filing this restoration petition.
Restoration petition.
My lord, it was dismissed for non-prosecution way back on
Who's for the
18
respondent? FCI.
FCI.
Is there a standing counsel? No.
Standing counsel, I think Mr. Chaudhary,
But
Mr. Roy. Is
then we'll have to issue a notice here.
My lord, I'll just ask him whether he can appear.
Please.
My lord. Let's come, my lord, after 2 days. I'll just ask him whether he can appear.
We'll take it up at 2 p.m.
Today, my lord.
Huh?
Yes, my lord, your lordship can.
At 2 p.m.
Oblige.
In this matter, I need 1 week time, Lordship,
It will do double.
to get our instruction.
Service upon private respondent has already been completed, my lord. 24 to 25.
Hmm?
Service upon the respondent but he has completed. My lord, against the cancellation of my appointment, a date may be fixed, my lord. I was without issuing any show cause notice, my lord. I was determined.
You are representing whom?
Lordship, Dima Lordship.
Dima has. In these small,
Number
small
1 and
matters,
2.
why don't you get your instructions there?
Lordship.
Third learned counsel for the parties, counsel for the Dima Hasao prays for 2 weeks' time to complete his instructions in the matter. List the matter after 2 weeks.
My lord, a date may be fixed, my
Why?
lordship. Petitioner was service was his appointment was cancelled, my lord, without it doing any show cause notice, my lord.
21st April.
Obliged.
Please get your instructions or we'll pass orders asking your officers to be present here.
All right.
Yes.
Maybe it is, my lord, this is for upgradation of the petitioner. If so, third grade court from the court, from fourth grade court. The related list is at page, annexure 1 at page 8, man. Number 1 is Romashwara, who was one of the rich petitioners expired recently. Second position is Awal Majid, the present rich petitioner, madam. The third, fourth, and fifth have already been promoted, upgraded to higher post.
Where is your appointment order? Appointment order?
Yes, sir.
PWD standing counsel, madam. PWD.
In paragraph 2, my lord of the petition, I mentioned that I was appointed on 1/1/1994. Petition number 2 was appointed as regular together.
Where is your appointment order?
It is not here, my lord.
Then?
Only upgradation letter is there.
No, but your
Sir.
appointment order will give you the, go to the root of the matter to show how you were appointed.
And they have filed their affidavit in opposition saying that as and when vacancy will arise, my lord, I shall be considered for upgradation. They are affidavit in opposition, page number 3, my paragraph 9,
Affidavit filed by?
filed by Executive Engineer PWD, concerned PWD Division. Page 3 at paragraph 9, last part.
Yes, Mr. Dhor.
My lord.
What happened after this order was passed?
Nothing happened. On repeated queries made by this honorable court, my lord, they replied that vacancies are existing. I have also filed an additional affidavit saying that the vacancies are existing. I paid
Vacancies in which post?
in third grade post one,
Grade 3.
grade 3.
Under what provisions are you claiming promotion?
Because, my lord, there is a policy of the government to update persons from fourth grade to third grade.
So what's the policy?
Policy is not with us, but it is stated, my lord, and they have admitted that there is
Yes,
a
Mr.
policy.
Dhor.
My lord, here the first thing is that this affidavit, my lord, it was filed the long back in 2014. My lord, now para 8 says that the answering deponent backs to state that there is no provision for promotion of grade 4 Chokidar to the post of section assistant. Section assistant, my lord, is a technical post, my lord. It is to be the required qualification is graduate.
High secondary science.
Fine. So, my lord, and there is no provision to, my lord, upgraded Chokidar to section assistant. This is our stand in the affidavit, my lord. So, I don't know what my learned friend is, my lord.
I am not for section assistant, my lord. I am for official assistant, junior assistant.
Junior assistant.
Junior assistant in the general. In which post my juniors were upgraded.
What is your qualification?
I am matriculated.
My lord.
Matriculate is not sufficient for junior assistant.
There is a graduate.
My juniors were of the same qualification.
Huh?
My juniors were of the same qualification who were upgraded.
You challenge their appointment. You challenge their.
I did not challenge because posts are there for my
Maybe
application.
posts are there. Somebody has been wrongly appointed. Doesn't give you a right to appoint wrongly in those posts, notwithstanding that you do not have the required qualification.
As per they were to produce the rule, personal rule, my lord. As per order dated 207/2023.
What rules govern this?
My lord will take up of this matter after some time. I have the soft copy of the rule, my lord.
207/2023.
My lord, the rule says that, my lord, the minimum qualification is graduate for a junior assistant.
All right, you take it up at 2 p.m. today. Will it be possible?
My lord, I can.
All right.
Or
you
the
want
day
it
after
on
tomorrow.
Thursday?
Or the day after tomorrow.
Day after tomorrow. Day after tomorrow?
My lord.
All right. Please ensure that this we
yes.
are recording your name.
My lord. My lord.
Please produce whatever rules are there.
My lord.
Mr. N.H. Mazhar Bhuiya appears for the petitioner. Mr. R. Thor, Landed Standing Counsel, represents the PWD department. As per earlier orders passed, the Standing Council was required to produce the PWD rules governing the promotion / appointment in the department in various grade 3, grade 4 posts. So, the said rules, however, are not available with Mr. Thor. He seeks a day's time to produce the said rules. Accordingly, let the matter be listed again day after tomorrow with the date, which is no. All right, 19th. On which date the Standing Council will produce the relevant rules. If you have a soft copy, please share it with the court master. Day after tomorrow.
Two occasion, Lordship, DLC considered the application but subsequently rejected, Lordship, on 2012 and 2018, Lordship.
In this case, 87 of 2024, none appears for the lead petitioner of the matter being called. This case is file seeking restoration of WPC number 1315 of 2021. Mr. A. Chakraborty represents the respondent. List again in the next week.
All right.
Here, my lord, I would like to draw attention to the first order, my lord, 9-1, 2017, my lord. In that order, my lord, the court had recorded that it is an association, my lord. It is not clear who is aggrieved in this case, my lord, because they are challenging the gradation list. So, my lord, they'll have to specify who is claiming which position, my lord, who is being aggrieved here. And that is why, my lord, even from the department, they are finding it hard to give instructions, because in order to defend its position, they'll have to know exactly, my lord, who is claiming discrimination or superstition, my lord.
My lord, they wanted to file affidavit in the position. And after receiving copy thereof, I would like to reply. So, this association is recognized by the government. So they have a right, the association have a right to challenge the illegal order issued by the government. So I may please be given an opportunity.
Respondents have filed an affidavit.
No,
Lordship.
they are filed. I have no.
They have not filed.
Initially, lordship, we were following the usual
The
course.
last that they wanted to file the affidavit. Like this, the years after years they have spent. So whether they will file affidavit in the position or not, this point may be clarified. Then I can prepare the case.
Yes.
Yes, my lord, we were following the usual course. We have supplied a copy also. We have received a query saying that, lordship, who is claiming a right here, lordship, because it is an association. If my lord see, there is not even a
may be, my
name.
lord. Whatever may be, I may be given an opportunity to reply.
And the other members in the gradation list are also not parties here, my lord.
But if these objections you want to bring it on record, you bring it. Otherwise, we'll close your opportunity to file affidavit.
We'll bring it on record then, my
So
lord.
after the 2000, what is this matter? 2017 matter.
Lordship.
Then
We'll bring that objection on record.
if you want to bring it, you bring it within 1 week. Beyond that, we are not giving you any further time. Please, we are making it very clear. Heard Mr. C. Deka, learned counsel for the petitioner, Mr. I. Botakur, standing counsel for it. Although repeated opportunities were granted to the respondents to file their objection, affidavit, the same has not yet been filed. Mr. Botakur has appeared before the court and prayed for a final opportunity to permit the respondents to file the counter affidavit in the matter. So, the counsel for the petitioner, on the other hand, submits that the respondents be directed to either file their affidavit or make a statement that no affidavit is called for, so that the matter can be listed for hearing. So, since Mr. Botakur has prayed for filing the affidavit, this court permits the affidavit to be filed within 1 week. Stop in the event the affidavit is not filed within 1 week, no further opportunity will be granted for filing the affidavit, considering that these two writ petitions were filed in the year 2017 and 15 respectively. Stop. In the event any affidavit is filed, the petitioners may file their rejoinder, if so advised in the meantime. Let this matter be listed again on 10th of April. 10th April.
Pardon?
10th April.
Obliged.
Lordship, the matter may perhaps infructuous, Lordship.
Right?
Lordship, the order for dismissal was, the order for punishment was imposed, Lordship. He filed this petition, the petitioner filed this petition for conducting the inquiry proceeding, early proceeding, Lordship. But it was disposed of, Lordship.
Inquiry proceedings conducted.
Yes,
completed.
Lordship. Completed, Lordship. Completed, and it was imposed punishment for dismissal, Lordship. Is the
Where is that?
the equity?
None appears for the petitioner involved, Mr. J.K. Goswami, appears for the Nana Governor Advocate, represents the respondent. Mr. Goswami submits that the prayer in the petition is seeking a direction for completing the disciplinary proceeding initiated against the petitioner within a period of 3 months. Stop. Pursuant to issue of notice, the department proceeded with the disciplinary proceedings initiated, and the said proceedings have been completed, and a punishment of dismissal has been imposed on the petitioner. Stop. He has placed a copy of the communication enclosing the order of dismissal issued by the disciplinary authority on the basis of the inquiry conducted. Stop. The in view of the having perused the communication placed before the court, it is seen that the office of the Commandant Battalion Training Center, Assam Dergaon, as the disciplinary authority by order dated 27/6/2023, has accepted the findings of the inquiry officer and has imposed the punishment of dismissal from service on the charged officer, namely SI within bracket UB Nipukolita of PTC, namely the petitioner herein. So, with that view of the matter, no further cause is alive in the present writ petition. It's notwithstanding the petitioner not being present, the counsel for the petitioner not being present, but it, keeping in view the prayers made in the writ petition, this writ petition stands displayed as in practice. In premortem, if any stands vacated, pending ayes or
Oh. Well, here is the case, my lord. Petitioner, her name was not listed in the for interview because he did not, my lord, fulfill the eligibility criteria. That is the case. We have filed affidavit, my lord.
You have filed affidavit.
We have filed affidavit. She belongs to other Anganwadi center, not this center which is advertised.
None appears for the petitioner on hold. Mr. T.C. Sutia, learned government advocate, submits that the affidavit on behalf of the respondents have been filed.
4.
Respondent number 4, Mr.
I am for respondent number 5, my lord. HR.
HR Chaudhary appears for respondent number 5. You have also filed something?
I have not filed affidavit, my lord. I will file, my.
Huh?
I will file affidavit.
You will file. This is a matter of 2023. When will you file?
Proceed, my lord, as per. That matter may be proceeded with. Affidavit is done.
So since none appears for the petitioner, matter is passed over. We listed again on 24th.
May I please your lordship? Lordship, the instruction is not received, your lordship. Your lordship, kindly fixed day may be given, your lordship.
None appears for the petitioner on hold. MS so and so. MS
J. Bora, lordship,
J. Bora
appearing on behalf of Mr. S. Doctor.
appears on behalf of the PNRD. Let the matter be listed after 1 week. The respondents in the meantime may complete their instructions. Mr. Bor Pujari, you appear?
I appear for finance, my lord.
Mr. Bor Pujari appears for the finance department,
Lordship, after 2 weeks, your lordship.
at least after 2 weeks.
I'm obliged, lordship.
May I please, Lord? My lord, the matter pertains to fixation of pay, my lord, and regularize the suspension period. And my lord, in the meantime, my lord,
Affidavit, my lord, we are awaiting the detailed instruction, my lord.
my lord, in the meantime, my lord, he was, my lord, retired from service, and after that, my lord, he expired. My lord.
Expired.
Petition expired. Now his pension is not regularized.
Do you want to bring the legal heirs on record?
Yes, ma'am. He has one son and daughter.
Mr. S.A. Ahmed appears for the writ petitioner who submits that during the pendency of the writ petition, the petitioner expired. He therefore prays for 4 weeks' time to take necessary steps to bring the legal heirs on record. There are Mr. R. Pujari appears for the finance department. appearing
For
for the finance
respondent number
department.
1 and 2, my lord.
For respondents 1 and 2, Mr. P. Chakraborty for respondent number 3, Mr. A. Chakraborty for respondent 5, Mr. Rohang for respondent number 4 does not object to the prayer made by the writ petitioner. Accordingly, matter stands deferred to be listed after 4 weeks.
Obliged. Last two occasions they was supposed to obtain instruction. Compassionate down, my lord, the SLC has rejected, stating that there is no vacancy of gate 3. As for OM, my lord, your lordship was also dispose of matter. If gate 3 posts are not available, they can consider for gate. At that apart, my lord, as per clause 15 of the OM, in any other department, they can consider, my lord. And similar, page
No, but
20.
now the government has brought out some compensation.
My lord, recently they have obtained.
So why should we force them to give you appointment?
But the petition was filed in the year 2023.
Maybe.
OM has been brought in the year 2024.
If it has to be reconsidered, let it be reconsidered in terms of the new office memorandum.
In the connected matters, my lord, same department, they have, Commissioner Book has directed to place the matter before the next SLC.
No, Mr. Sharma. If you are challenging your rejection,
yes,
is one thing. That you have been wrongly rejected, procedure not followed.
Yes.
But if your claim is that no, let my case be reconsidered for vacancies which may be arising in other departments, etc. Now that you do not have the information whether any vacancies are available.
Therefore, they were directed to obtain instruction. Last two occasions.
Yes,
Lordship, it is covered the case of Debabrata Tiwari, Lordship.
where is that?
What Debabrata Tiwari said, Lordship, the
Page number.
Normal immediacy that as per Supreme Court.
the Supreme Court judgment, Lordship. Para 7.5.
Ada poem or para 15 hour interest.
So,
My lord, on that basis of that judgment, my lord, and form has been passed by the department, personal department. That is under challenge in a series of petitions. So we have not challenged that OM because our petition has been filed in the year 2023.
so
Let it come next week. Then we'll
what is the status of the writ petition there?
Lordship,
Fixed
it is
tomorrow.
fixed on tomorrow, Lordship.
Mr. N. Sharma for the petitioner, Mr. A. Chakraborty for the respondent. Number 1, 2, 3. For all,
No, Lordship.
Only one.
Only one,
One and
Lordship.
only one.
1 and 2.
1 and 2, Lordship.
1 and 2.
Sericulture department. 1 and 4 is sericulture.
1 and 4.
Lordship, I am appearing for 2 and 3, Lordship.
1 and
2 and 3.
2
Who's
and
for
3.
sericulture?
Lordship.
For 1 and 4, Lordship, sericulture.
MS
And they on behalf of Ardhar.
and they. And they.
And they.
Appears on behalf of respondents 1 and 4. Counsel for the respondent submits that this matter is covered by judgment rendered by the apex court in Debabrata Tiwari. So he submits that in view of the law laid down by the apex court, no further claim applied in the description. So there. The counsel for the petitioner on the other end submits that following the judgment of the apex court in Debabrata Tiwari, the state government has brought out subsequent notification
18 September 2024.
on
Lordship.
18 September 2024,
20.
by which no further appointments on professional ground are to be considered by state government. rather, government has brought out the notification for awarding compassionate family pension
Family
if found to be active. Mr. N. Sharma, Mr. N. Sharma, on the other end, that this notification is put to challenge in a batch of the petition that the matters are fixed tomorrow.
Tomorrow, Lord.
We therefore submit that this petition be deferred for some time to apprise the court on the basis of about the outcome of the litigation, in which the recent notification has been reporting that this matter be listed on the court.
God bless.
The parties will apprise the court about the status of valid rate, the notification dated 18/9.
18.
18/9/2020.
24. God bless.
But here, I am required to file the affidavit. But somehow it left my notice. Today, during course of the day, I am filing. Kindly give me 2 days time.
That the affidavit will be filed during the course of the day.
Lot.
The counsel for the petitioner does not object in prayer day. And let the matter be listed after 2 weeks, by which time the respondent are required to file their affidavit, and the petitioner is also permitted to file the reply affidavit if so advised in the meantime. You are appearing? Okay. Mr. M. Smith appears as the respondent. Yes.
Hold on.
My lord, in this case, my lord, the petitioner has taken my lord voluntary retirement. So, my lord, matter has become in flux of.
Mr. Remy Mandal, petitioner on instruction submits that the petitioner has availed of the voluntary retirement scheme offered by the department. She therefore does not wish to pursue the petition any further. So, respondents do not object to the prayer made. Accordingly, is not pressed. Retirement many indicated. Pending IAs are also dismissed.
Obliged.
Yeah, please, regarding pensionary benefit of the petitioner. Madam, petition number 3 has expired, madam. We have filed another one IA for substitution, madam, record, madam.
IA is listed today.
Madam, we filed, madam, 22/8/2024, madam. Not in record, madam.
You have filed it.
Already filed, madam.
Counsel for the petitioner submit that IA has been filed seeking substitution of the legal heir in respect of petitioner number 3. What is the name?
Tikaram Odhikari, madam. Tikaram Odhikari.
Sri Tikaram Odhikari, who had expired during the pendency of the petition. So, said IA has, however, not listed in the report. Let this petition be listed. He therefore submits that the matter be deferred, be listed along with the IA. Registry to verify whether any IA has submitted by the petitioner has been filed, and if so, and if the same is cleared of defect, the IA can be listed along with the petition of the case. Mr. Rai Botakur for instance. For instance. Mr. SKPD for accountant. Accountant general.
5 and 6.
Mr. E. Chakraborty for respondent 5 and 6. Please take it.
Okay.
May please your lordship. Lordship, here we have challenged the dismissal order, lordship, and there is a great impropriety, lordship, while in the inquiry proceeding, your lordship, because I was not given an opportunity to cross-examine the prime witnesses, your lordship.
Affidavit's not filed.
Well, we have not filed affidavit, we will file short affidavit, my lord. In the meantime, my lord, records, my lord, we have received a photocopy, my lord. Original record we have not received.
You call for it.
My lord?
You call for the records if you want.
Yes, my lord. Because I will have to see, my lord, records.
How much time are you praying for?
3 weeks time, my lord.
This is a dismissal.
Dismissal.
Without any service, your lord.
Mr. D. Das, counsel for the petition. Appears for the counsel. Appears for the petition. Mr. Thesis Kutia. Done government application for all.
Lordship, there is an issue, lordship. We have made the inquiry officer as respondent number 5, your lordship.
You
because we
appear
have
for
only
1, 2, 3, and 4.
4, lordship.
4, my lord.
You have taken steps on respondent 5.
Lordship, actually, by the last order, lordship, there is a, because the court was not inclined to pass any notice upon the respondent number 5, because, lordship, but we have gave statement, lordship, against the inquiry officer also, lordship, in page
Right,
number.
then if notice is not there, then
Let it be, lordship.
His name is there.
Reveal everything, your lordship.
His name is there, my lord. He's as a party respondent. He should get notice.
Later, lordship, if notice is required to hear him, lordship, then lordship may issue notice upon him, lordship. Later stage after perusing
appeal
the
for
records.
respondent 1, 2, 3, 4. By earlier order dated 6/10/2023, notice on respondent 5 has been dispensed with for the time being. Accordingly, the counsel for the respondents 1, 2, 3, 4 will file, is permitted to file their objection / affidavit, if any, in the meantime. Stop. Let the matter be listed after 4 weeks.
Lordship, any date, lordship, let it be after 4 weeks, but the date may be fixed. I'm requesting.
21st of April.
Much obliged.
May I please, your lordship. Lordship, last occasion, I was asked to obtain instruction, your lordship. Lordship, PPO has been issued in favor of the petitioner, your lordship.
PPO has been issued.
Lordship.
Yes, Mr. Sharma.
Baromat.
There is a prayer for release of area. Has that been released?
Area would be released by the Departmental.
Yes, Mr. Sharma.
So far, this contains only release of 23,000 something, my lord. So for the petitioner self-deposit amount is concerned, that was not mentioned here in that. And he is, my lord, drawing, no doubt, my lord, the provisional.
You get your instruction.
So far, instruction given to me, that he is drawing only the, my lord, provisional. So for this 23,000 something amount, I'm here paying my self-deposit amount be released as well as the regular payment. In the year 2021, I was.
No, but this is the issuance of PPO.
Lordship.
PPO has to be for regular pension only.
No,
This is for the regular.
So for the other retail benefits is concerned,
That
he
we
is
don't
not
know, but
receiving.
that we don't know, but whether he has received or not.
So for provisional pension, he is receiving. Other than provisional pension, he has not received.
No, pursuant to this order, it was passed on 12th of March.
He may not have received my, I have to take it up to that
That's
effect.
right. Counsel appearing for the Accountant General,
Lordship, R.
Yes.
Boro.
R. Boro,
Lordship, on behalf of C. Boro, Lordship.
on
For
behalf
respondent
of
number
C.
8.
Borua. Has placed before the court copy of the communication by which the
CPU and GPU.
pension payment order in respect of the writ petition, pension payment order within bracket PPU has been released. So counsel for the petitioner on the other end submits that he would like to complete his instructions. So he further submits that there are other prayers in the writ petition for release of area DA, shortfall in basic pay and area DA on the house rent. So the council representing the, which department is it? Industry?
Industry.
What is your instructions with regard to this?
Right now, Lordship, I have not received any.
Council for the Industries Department also prays for time to complete his instructions in respect of the other prayers made. Stop. Who's appearing for BTC? MS. A board, whatever appears for respondent number 2, the BTC. Stop. Let the matter be listed after 3 weeks.
Let it be 2 weeks, madam. Date may be.
After 2 weeks. On 4th, on 7th April.
7th April. Right.
Oblige, your Lordship.
Lordship, departmental affidavit is ready. It was sent for signing, Lordship. Kindly give us Lordship to file the same.
Yes, Mr. R. Islam, legal counsel appears for the petitioner, MS
J. Gogoi, Lordship.
J. Gogoi, counsel representing the
ASTC, Lordship.
ASTC, submits that the affidavit will be filed within a period of 1 week
Yes, sir.
from today. And Mr. R.B. Goswami appears on behalf of respondent number 1. Let the matter be listed again after 2 weeks.
Oblige, Lordship.
82.
May I please, matter regarding suspension of the petitioner, my lord. The suspension order is at page number 23, annexure 6. It was alleged that madam the petitioner have misused the digital signature of the then superintendent, my lord. How can it be possible, my lord? It is not possible for the petitioner. Because the token of the digital signature.
No, you are challenging the suspension order.
Yes, my lord. And
suspension order
is a 9th of.
whether any departmental proceedings have been
Nothing.
instituted?
No review notice, nothing has been
Yes.
done. 9th of October, they
So
suspended.
who is
my
for
lord.
the finance department?
37. Earlier, Mr. P. Chaudhary and P. Gogoi, they have appeared. They've taken the 5th time for filing affidavit, my lord. It's been more than 6 months, my lord.
Yes, finance. We'll take it up at 2 p.m. Or you find them, if you find them, please tell them.
Yes, my lord. I've left.
Yes.
My lord, why? Appointment of arbitration. My lord, partnership deed shows at page 21, my lord, that contains the clause, my lord, regarding their petition. Page 21. Clause 22.
Yes.
That all the disputes and differences by and between the partners and all associates doing business with a partnership hereto arising out of or connected with any of the provisions hereof, or anything done in structures thereof, including those relating to retirement and cessation of any partner or dissolution of the partnership, if the same cannot be settled mutually, shall be referred to arbitration. This is the close manner, and the close is very wide matter. Now, my lord, so far the other side is concerned, he is one of the partners, my lord, along with me, my lord. And by letter dated 29/24, your lordship will see at page 32, and relevant portion is at page 39 and 40. Paragraph 13, my lord.
Yes.
That in spite of misrepresentation used fund by the firm, as indicated in the foregoing paragraph, and refusal by you to discharge the paying charges in loan life as detailed and discussed above, to cause wrongful loss to me, you issued a notice for retirement under section 43 of Partnership Act on false and fabricated grounds without discharging your liability to the appointment or action has been necessitated. Next, para, my lord, 40. That under the facts and circumstances, I appoint CA Manoj Naka, care of such and such as my arbitrator to arbitrate the disputes and differences arising between us in relation to the firm. It is request to you either to consent such appointment or alternatively you are requested to suggest the name of your arbitrator. Subject to my approval for the purpose of reference within a period of 30 days from the date of this hearing is I shall approach the Honorable High Court for appointment of which brief form.
Yes.
So, my lord.
My lord, I have some objection in this petition, because if your lordship kindly sees the partnership deed, it's a partnership at will. Then a partnership will is defined under section 7 of the Partnership Act, and section 43(1) says if it is a partnership at will, it can be dissolved by serving a notice to the opposite party. Now here we have already issued a notice under section 43(1), which is page 27 of this petition. There are some more documents which have not been annexed here. I would like to place all those documents by way of affidavit in opposition. This is a notice under section 43(1), and some of the high courts has held that when a notice under section 43(1) has been issued by one of the party dissolving the partnership, there cannot be any there cannot be any force to go for arbitration of the dispute. I'll place those judgment at the time of hearing. I may be granted 2 weeks time to file an affidavit in opposition.
Yes, Mr. Bhatti.
My lord, 1 week, because the matter is urgent, let it be 1 week. He may file it.
Come to page number 39. 39. No, come to page number 39.
39, yes, sir.
Error number 13.
Disputes is from 2021.
Hmm. You have used the term
Yes.
misappropriate.
Misappropriate.
By whom?
By the other partner, the opposite partner. Yes.
So you are making a criminal allegation against him.
Yes, I have similar means I have made the allegations against him because he was one of the partners of the firm.
No.
And accordingly he misappropriated.
Misappropriation is a term to be used when somebody unauthorizedly takes away the money.
Yes, that is
so
the thing.
that gives rise to a criminal complaint.
No, even though apart from the criminal proceeding, there is also the arbitration. Your lordship will come to the arbitration clause again.
No. The question which we want to ask you is if there is a criminal allegation made.
That is, your lordship is absolutely correct. So for the misappropriation, I can go for the criminal. But even though, because by proceeding for misappropriation fund in criminal court, I may not be able to realize the amount. And for the purpose of realization, I have to go for arbitration since there is a clause.
I will bring
We will
those.
examine all that. But if you allege misappropriation, then what is there to arbitrate?
Yes, misappropriation is there.
What is to be arbitrated? What is to be decided by the arbitrator?
The arbitrator will decide whether actually there is a misappropriation, whether I am
That is for a
enti-
court. That is
no,
for a court
whether
to
I am
decide.
entitled to refund on account of misappropriation.
So
of the fund.
you are asking the arbitrator to step into the shoes of a criminal court.
No, that is not the thing. They will go through the account and they will see what amount the other side has misappropriated.
But will the arbitrator be authorized to do it? Assuming we appoint,
Yes.
can the arbitrator return a finding that you have misappropriated, therefore
No,
return
they
this
will.
amount?
In fact, criminal proceeding is pending.
Yes. They would come to that conclusion whether there is a
It may
misappropriation
or
or
it
not.
will not be binding
Whether
on a
I am
criminal court.
entitled, whether I am entitled to my share or not.
So we just wanted to ask you about this because you are using the term
Yes,
misappropriation.
I will also produce the judgments of the different Honorable Supreme Court and different High Court that in case of misappropriation too, the arbitration can be.
Mr. O.P. Bhatti, learned counsel appearing. There is a change in counsel. Is there a change of counsel?
Yes. Mr. Saiwala has retired.
Mr. O.P. Bhatti, learned counsel appears for petitioner. Mr. R.
Aidhol.
Aidhol appears for the sole respondent. Mr. Dhol submits that he would like to file an objection, bring on report the relevant documents. In as much as the partnership between the petitioner and the respondent was a partnership at will. And he had already issued a notice dissolving the partnership. Under such circumstances, there is no arbitration agreement which subsists between the parties. So, let this objection be filed before the respondent, by the respondent within a period of 2 weeks.
2 weeks.
2 weeks.
Obliged.
I will let it to 1 week
Right.
or 10 days.
2 weeks is good enough. Instead of giving him
In
further
first
opportunity.
week of the next month, I am leaving for that. That's why it is my
10 days. He filed within 10 days.
Ballot.
And
Probably after filing that, he might have to give a reply. Senior
It
friend.
may not be
may
requirement
not
of
be
giving the
reply.
reply.
Obliged.
The matter be listed after 10 days.
Matlab.
This matter will be taken after some time, like, the senior is coming, my lord. Affidavit has been tagged, my lord.
Yes.
Time lagi. Nanti kurang na. After some time.
All right. At 2 p.m.
2 p.m.
Yes.
My lord, in this case, the notice was issued for the appointment of arbitrator, and at page number 99, my lord.
'99
Yes, my lord, last,
of the writ petition.
yes.
Your writ petition is up to 96.
95,
Amended-
my lord. 95.
95.
Amended petition has been filed, my lord.
Amended petition.
Yes, my lord. In the amended petition, my lord, 99, page 99 and 100, last 2 pages.
Yes.
And despite receipt of this Later, my lord, they did not act upon the a, arbitration clause, my lord.
Yes, what do you say? Where
My
is the agreement in the first place?
At page number, my lord, 61.
Where is the arbitration clause?
In the bottom, my lord, clause number 63. Matter finally determined by the railway.
All right. And where is your work order?
Work order, my lord, agreement. Agreement is at page 20, my lord.
Yes.
And this arbitration clause is part of the agreement. So once, my lord, they fail to act as required under the agreement, now your lordship may appoint the arbitrator. It
What
is
do you
settled
say?
law.
What
My
do you
lord, I have filed our affidavit in opposition to the first one. The amended petition is that it was, they stated that it is a partnership, okay, proprietorship firm, my lord. Thereafter, they amended, they said it is a proprietorship firm. I have already filed our affidavit in opposition in the first one, my lord. That the 95, that is the application for invocation of arbitration clause, my lord. That was not submitted or not aware about the submission of this application, my lord. Because after the receipt of this writ petition, we have tried to trace out the same, but we could not, my lord, because there is no uh, uh, at page page page, my lord, 265 or affidavit in opposition. To the law officer, it is a communication within the
in your paragraph, in your affidavit, where have you stated?
that at 11, my lord.
Para 11.
11, my lord. Para 11, my lord. At page 102, my lord.
They have
my
made
lord,
an averment that they
my
did
lord,
not receive your
In
notice.
yes, and in my reply, my lord, I have annexed this AD card as well as the postal receipt, my lord.
my lord, next 266 would tell of all the arbitration proceeding report. 266, my lord, submitted by the petitioner. That is, the petitioner claimed that he is submitting for arbitration on 29/11/2019, but this letter has been submitted on 12/11/2020, withdrawing all the proceedings, arbitration proceeding before that. The petitioner himself withdrew the arbitration proceeding, all the arbitration proceeding before the.
No, we are not concerned with all. We are concerned with only this contract which is before the court.
Yes, my lord.
Now, your statement that it is not available.
Not available, my lord.
Is being
Perhaps,
disputed.
perhaps it is 266. He withdrew all the arbitral proceedings.
No, if he has withdrawn also, then your letter must be there to show that.
My lord, I have stated in para 12. I have asking for some documents, but he has not salan and invoice.
Since the pleadings are complete, this court considers it appropriate to fix the matter for admission hearing. Is this matter again on 3rd of April? 3rd of April.
My lord, thereafter, my lord, I mean, 8 on next
8th of
week.
April. List on 8th of April. Yes.
Wait, but the petitioner to lawsuit was appointed as computer operator which came from 1/1/2009. He was working as such, my lord, but no remuneration was paid to him. And while he approached this honorable court, my lord, claiming the remuneration, he was not allowed to attend the duties also after coming to know about the filing of the petition. He was not allowed to perform his duties also. Now, limited claim is that, my lord, from the date of initial engagement, my lord, till his no finally, formally he was not, my lord, discharged. He was not allowed to do the duty. After
Where is your appointment order?
Lord will find that order at page 19, my lord, in the original affidavit, my lord. I have an extra. Page 39. Connection 19, page 39.
In the rejoinder?
In the additional affidavit, my lord.
Additional affidavit. Page number?
Page number 39.
Yes.
Yes, sir, my lord. Here they have issued various certificates, my lord, from page 18 onwards, my lord. Various proposals were also sent for regulation of my service, as my service was required under the division. But nothing was done. My limited claim is that I am not claiming the regularization as it is not permissible. I am only claiming the, my lord, salary for the period for which I have rendered my service. They have my lord, finally made an inquiry. In the inquiry also, my lord, they found that, my lord, appointment was issued, but it was without the approval of the authority. This says that, my lord. As it may, my lord, they have admitted in the regulations, my lord, that I was appointed. And I was allowed to continue. Only after approaching this honorable court, my lord, I was not allowed to perform my duty. Claiming the regulation also.
But what is your basic claim even for the salary? Because unless your appointment, whether in temporary, contractual, has to be as per the procedure.
That is,
Now, if somebody decides to appoint you, whatever reason, then your claim at best will be against that person. Why against the government?
No, my lord, the various officers, not only that particular person, my lord, you find from page 18 onwards, the various officers, my lord, not only the particular person, my lord. All of them, my lord, they have admitted that I was working, my service was taken by them.
Yes, Mr.
My lord will just peruse the order dated 23/4/24. They are the direction on the commissioner, my lord, to make an inquiry into this by this honorable High Court, my lord. And thereafter, my lord, the commissioner has made an inquiry, my lord, and the inquiry report has been brought on record by way of an affidavit in page number 64. So, my lord, basically.
76, my lord, should be page 76.
Oh, 76, running page. Okay.
76.
76, my lord.
What is the inquiry report?
My lord.
This is the inquiry report, my lord. In the inquiry report, my lord, all the officers, my lord, who issued those certificates and my lord, proposals,
My lord,
they were made party.
my lord,
Yes.
let us, my lord, read the inquiry report, my lord. This is done by the direction of this honorable High Court, my lord. May I read, my lord? On scrutiny, it is found that no any appointment letter was issued to Raju Bhaiya, writ petitioner, as computer operator by the executive engineer PWD, Saraido District Road Division, the then Saraido Railroad Division. However, Mr. Bhavendra Dole, who was the then executive engineer, issued an office order dated 1/1/2009 without approval of the higher authority or the government. Also, there was no mention of any financial involvement or any other such criteria in the said office order. No contractual agreement or any other MOU was signed between the office of the executive engineer PW Saraido Railroad Division and Sri Raju Bhaiya with regard to any monthly pay or salary or any wages under the rule. Raju Bhaiya for some time period worked part-time voluntarily on his own as a volunteer type to gain some knowledge and no consideration for any salary was fixed or even discussed. It was purely voluntary engagement done on his request, my lord, on his request. Experience certificate was issued to Raju Bhaiya for his voluntary service, and it was issued to him under seal as a goodwill gesture, so that such certificate could be useful for his future employment, etc. And in no way the certificate could be termed as an engagement letter or appointment letter, etc. Conclusion. The statement furnished by the executive engineer have been thoroughly examined along with all the relevant records in this regard, and as stated, I have carefully examined and considered the facts and circumstances of the matter. In his considered opinion, Sri Raju Bhaiya has taken advantage of the experience certificate as issued from time to time by the concerned executive engineer on his verbal request, so that such certificates could be useful for his future employment, etc. Also, there is no sanction post of computer operator in Saraido District Rural Road Division, Sonari. Further, no such records of his official procedure required in such appointments were found in the office records. Hence, official appointment of Sri Raju Bhaiya as computer operator does not arise. So, my lord, basically, my lord, we have never, an executive engineer doesn't have a power, my lord, to issue notice unless there is a sanction post or by lord without the prior approval of the department concerned and financial concurrence, finance department concurrence, my lord. Because money have to come from somewhere, my lord, to make the payments. There was nothing as such, my lord. Basically, my lord, it's a covered case by Mamata Mohanty, my lord. If we, my lord, take the ratio of Mamata Mohanty laid down by the Honorable Supreme Court, the very inception of the service, if the inception of service, my lord, there is nothing, my lord, to prove that he was and he entered into service, my lord, through a regular process, my lord, he will have no claim. So, my lord, basically, we are even aghast, my lord. We never appointed him. That is our claim, my lord. All throughout, my lord, we stated in our affidavits that we never appointed him.
But your executive engineers have been writing to the chief engineer for putting him on contractual basis, etc. Why?
My lord,
Why these letters have not been considered by the commissioner?
my lord, consider, suppose somebody writes and my lord, government doesn't take a call, means it is deemed to be refused, my lord. It is not that, my lord, government, my lord, executive engineers from all divisions, they keep on writing, my lord, because we even know, my lord, everybody is not clean. They may have taken some personal interest into it. So, my lord,
This was required to be examined by the commissioner and secretary in the report. There is no mention of these letters written by the executive engineers. Either you say that these are not available in record, these are forged, created. There is no mention. At least something should have been there to say that these letters were issued, were not authorized by the officers.
but my lord, at the end of the day, my lord, whether, my lord, such appointments.
No. End of the day, he may not have a claim for regularization.
No, regularization, but my lord, there is no claim.
If you have made him work, where if your officers allowed him to work, he has to be entitled for some amount.
My lord, we said we did not, because inquiry found that, my lord, he came voluntarily, my lord.
No. Your communication by the officers to the chief engineer, come to page number 26.
My lord.
Yes. He says he was serving as a contractual computer operator. Now,
My lord, if there is a contractual thing, there has to be MOU and some documents.
that's right. But if
There is nothing.
If it is not there, then what steps have you taken against your officer, the executive engineer who was holding office? Either this
My lord,
settlement-
my lord, that is again a separate.
The question is whether he was allowed to work. The department at the various levels, this is at the executive engineer level. He has worked in the executive engineer's level. Chief engineer or commissioner office, he has not worked.
But my lord, the thing is that at the end of the day, money has to come from the source.
So if it has not come, then the commissioner was duty bound to say that if the officer was not authorized to give him contractual appointment,
That is
whatever,
what we stated in inquiry report, my lord.
whatever amount is required to be released has to be released from the personal finance of these officers.
My lord, the thing is that the very claim of any amount, my lord, that has to be established first, my lord. My lord will fix this matter for hearing, my lord. I will come with all the judgments of Supreme Court, my lord. What Supreme Court has
Judgments
laid
will
down for,
come,
my lord.
But give us the clarity on facts. Your commissioner has produced a report where there is no reference of these letters. Either these letters are not in existence, then you say that these are not in existence, it's not available in file. And if these letters are there, and these officers know that they were not authorized to appoint somebody on contractual basis, then what steps the department has taken against these officers? It is because of their conduct that people like the petitioner are coming before the court praying for grant of salary or wages. These officers are responsible for creating a burden on the government.
My lord, the report says that he did whatever he did, it is voluntarily.
No, but these letters don't say so. It says contractual appointment.
28, my lord.
Contractual appointment means there was a contract. Somebody has entered into a contract.
My lord, then there has to be some documents. There is no existence of any document that he was.
What steps have you taken against these officers? If these officers have retired, you have to call them up call them out of retirement to find out
My
what
lord
is
will pass an order, my lord. Just pass an order, my lord. I will take steps that these people are.
We will not pass an order unless you tell us that these documents were considered and found to be not
My
in
lord,
existence.
my request is, my lord, my prayer is, my lord, we will say that this enquiry is inconclusive because these did not address the letters, my lord.
That's right.
My lord, we will go for further enquiry and make those officers accountable.
Page 76, if you look at Perus, here, my lord, all the executive engineers are there.
No, but this gentleman is not there. He may have retired in the meantime.
My lord, my lord. Tonkeshwar Hazarika.
He may have retired.
The other executive engineers, my lord, they have made a party to the inquiry report also.
You see, come to page number 30. Come to page number 30.
My
See the name of the person who has written this letter.
Bhupen Gogoi.
Yes. And now come to page number 76.
Open Gogoi. Serial number
His
3.
name is there at serial number 3.
Yes, my lord, we called everyone.
You called, but there is no reference whether these letters were indeed issued or not. If they are issued, then under what capacity?
That is what, my lord,
Heard Mr. Wright's Social Learned Counsel for the petitioner, Mr. Radford, Listening Counsel for the PWD Department. By earlier order dated 23/04/2024, the Commissioner and Secretary, Special Secretary to the Government of Assam PWD was directed to cause an inquiry by himself into the matter and file an affidavit within a period of 1 month. Stop. Pursuant to the order issued by the court, the inquiry conducted by the Special Commissioner and Special Secretary PWD dated 16/5/2025 has been placed on record by way of an additional affidavit filed by the PWD Department. Stop. The inquiry has the relevant portion of the inquiry report is extracted below page 76. Stop. Better. The counsel for the PWD therefore submits on the basis of the inquiry that no appointment letter, comma, or contractual agreement was found in the records, and that the petitioner had worked for some time voluntarily and no consideration for any salary was fixed or even discussed. Stop. Experience certificate issued to the petitioner was in respect of his voluntary service rendered. Stop. Para. Upon perusal of the pleadings available before this court, it has come to the notice of the court that there are as many as 3 communications issued by the lead and executive engineer PWD, Choraido Rural Road Division, Sonari. Stop. Sonari, which reveals that the petitioner was working under the Executive Engineer PWD, Soraido Rural Road Division's office. Stop. By communication dated 1/9/2018, addressed to the Chief Engineer PWD Roads, Executive Engineer PWD had requested for considering the case of the petitioner for appointing him to the post of LDA in the office of the Executive Engineer PWD Soraido Rural Road Division. Stop. Thereafter, by communication dated 19/10/2020, the then Executive Engineer PWD Soraido Rural Road Division had submitted a communication to the Chief Engineer PWD Roads requesting for permanent absorption in the vacant post of LDA in so far as the writ petitioner is concerned, as he was found to be serving as a contractual computer operator with effect from January 2009 till date. With dedication, sincerity towards the government services without any benefit for the last 10 years. So, these communications are besides the representations preferred by the writ petitioner before the competent authority, praying for grant of praying for regularization or end of legal absorption.
Page 31, my lord.
So, that is one, you write 3 dates, 4/12/2017, 19/10/2020, and 1/9/2018. Stop. A perusal of the inquiry report enclosed to the conducted by the Commissioner and Special Secretary to the Government of Assam PWD Department. PWD does not deal with these communications and the manner in which the petitioner was claimed to have been allowed to work for on contractual basis. Stop. These aspects are not reflected in the in the inquiry report conducted by the Commissioner, Special Commissioner, and Special Secretary, PWD. Stop. Under such circumstances, we direct the Special Commissioner and Special Secretary to revisit the inquiry conducted, and after proper examination of all materials available, file conduct the inquiry and place it before the court by way of an affidavit. Stop. The inquiry must reflect under what circumstances the petitioner, the inquiry must reflect whether the petitioner, inquiry must reflect under what circumstances the communications referred to above have been issued by the then Executive Engineer PWD, Soraido Rural Road Division, Sonari. Stop. And if the said communications were not authorized to have been issued by the executive engineer, whether any steps in this regard have been taken against the officers concerned. Let the matter be listed again after 4 weeks.
My lord will fix a date for time for inquiry, my lord. And then only,
The inquiry will be conducted within a period of 3 weeks,
my lord, 4 weeks, my lord.
4 weeks.
4 weeks.
And the matter be listed thereafter. List this matter again on 21st April. We'll give you some more time, 28th of April.
My lord.
Copy of this order be marked to the office of Mr. R. Dhor, Standing Counsel PWD for onward communication.
My lord, in this case, the arbitration clause is at page 55, my lord.
Yes.
Clause number 25. Except where otherwise provided in the contract, all questions and disputes relating to the meaning of the specification, design drawings and instructions herein before mentioned, and as to the quality of the workmanship of or materials used or on the work, or as to the contract, or as to the contract design and drawing specification, estimates, instruction orders, or these conditions, or otherwise concerning the work or execution or failure to execute the same when the arising during the progress of the work or after the cancellation, termination, completion of or amendment of the thereof shall be dealt with as mentioned herein after. If the contractor consider any work demanded of him to be outside the requirement of the contract or dispute any drawings, record or decision given in writing by the engineer in charge, or if the engineer in charge consider any act or decision of the contractor on any matter in connection with or arising out of the contract or carrying out of the work to be unacceptable and is disputed, such party shall promptly within 15 days of arising out of the dispute request the chief engineer CPM, or where there is no chief engineer CPM, request the additional director general, special director general, who shall refer the dispute to dispute redressal committee within 15 days. This is important, my lord. Within 15 days, along with the list of disputes with amounts claimed, if any, in respect of each such dispute, the dispute redressal committee give its decision within a period of 60 days, extended by 30 days by the consent of both the parties from the receipt of the reference from chief engineer, CPM, ADG, SDG. The constitution of dispute redressal committee shall be as indicated in the schedule F, provided that no party shall be represented before the dispute redressal committee by an advocate, legal counsel, etc. Now the DRC will submit its decision to the concerned ADG, SDG for acceptance. ADG, SDG in a time limit of 30 days from the receipt of DRC decision will convey acceptance or otherwise on the said decision. If the dispute resolution committee fails to give its decision within the aforesaid period, or the ADG, SDG fails to give his decision in the aforesaid time limit, or a party is dissatisfied with the decision of the dispute redressal committee DRC, therein, then either party may within a period of 30 days from the date of
All right.
receipt of
What,
the
what,
decision
what
of
is
the
the respondent's
my lord,
claim?
Yes.
What is you filed your objections here?
Yes, yes, Lord.
What is your objection here?
Yes, he has to first, he has to place this claim before the DRC or not. Okay? Then, if he has within the 30 days, extend the 90 days,
If the gift fail to give the your lordship adjudicate the matter, then he will come to the arbitration, your lordship. Without exhausting the your lordship DRC, he straight will come to the lordship 11 section 11 arbitration act, your lordship. Your lordship, page 56, your
We'll hear
lordship.
the matter. Fix a hearing date. 1st of April.
1st of April.
8th of April. 8th of April. Since the parties have exchanged the pleadings, matter be listed for admission hearing on 8th of April.
May I plead your lordship, in this matter, senior standing counsel, Mr. K. Kaur has appeared in this matter, lordship, but today he has some personal difficulties, your lordship. Your lordship, kindly matter may fix after 2 weeks. It may be fixed, lordship. Otherwise, pleadings is complete, your lordship, in this matter.
Parties have submitted that the pleadings are completed in the matter. Matter can be listed for admission hearing. List on.
He is not getting salary, man.
Huh?
He was not allowed to join. He is not getting salary.
22nd of April.
My lot of like.
Obliged, lordship.
Right, reason.
May I please lordship? My lord, today I have filed my lord on behalf of the number 5. So, my lord,
Well, petitioner has already been retired, my lord, he is more than 70 years. The correction of date of birth. We have filed affidavit, my lord, we have narrated all these things. His date of birth is 52. And
Yours, what is your prayer here?
Lordship, her date of birth is 69. I don't know from where they have got it, your lordship. In this case, it is the date of birth which is at the contention, your lordship, contentious issue. And just take a lordship to annex your page 15, your lordship. The school certificate. This is the time of my appointment, your lordship. The date of birth that I have given, I have never changed it, your lordship. And this is the date of birth which says that I have
No,
almost.
we'll hear the matter that requires some amount of
yes,
hearing. You are appearing for 5.
yes.
Fix the date, your lordship. Because the records are very clear. I have brought all the original records also, your lordship. There is no handkeeping, there is no.
But there are at least 2 orders which say that time was granted to the petitioner to file reply affidavit against the.
No, we have granted everything. Affidavit.
Then why your appearance is
I
now
have been engaged today itself, my lord.
on behalf of respondent 5?
Yes.
Mr. Amit Toskor appears for the petitioner. Mr. T.C. Sutia, learned government advocate, appears for
1, 2, and 3, 4.
1, 2,
1 to
3,
4,
and 4. Mr. K. Hussain submits that he has been engaged today to appear on behalf of respondent number 5. He therefore submits that sometime they granted to him to complete his instructions in the matter. Counsel for the petitioner, on the other hand, submits that the pleadings are complete in the matter. Then we'll issue rule and matter be listed
lordship,
for hearing.
It will take a lot of time, your lordship. Admission hearing, lordship will.
All right.
skip to it.
Matter be listed in the month of May for admission hearing on a date to be fixed by the registry.
If lordship after hearing finds that there is something, your lordship, lordship may issue rule also. But otherwise, you will be deprived.
If we hear it, then we hear it. What is this point about issuing a rule after hearing?
Oblige, lordship. Right, please. Your lordship, can you peruse the last order? Learned government advocate was directed to seek certain instructions as to why the benefit under open judgment should not be extended to us.
Yes, Mr. Sutia.
Actually, my lord, what happened? A GATA will appear, my lord. We file earlier affidavit. And now, my lord, the matter, my lord, they are conducting the, my lord, GATA, my lord. So Podmore Nayak, I think he appeared last week.
Who appeared?
Podmore Nayak. One affidavit is filed earlier by us. Now response number 3. The name is not shown. GADA Standing Council name
It
is
is
not shown.
submitted by Mr. T.C. Sutia, learned government advocate, that the respondents, which respondent?
Response number 3.
Respondent number 3
3.
and 4.
So, petition number 4.
3 has filed the affidavit.
Hmm?
3 has filed affidavit and now.
Are you representing any
Yes,
of the?
yes. No,
You are
but
representing one.
Response number 3, my lord. Now, the Secretary Administration Department by Standing Council 2, 3, and 4.
Yes, Mr. Bhukan.
Just been informed.
Mr. T.C. Sutia, appearing for respondent 1, submits that
Only one.
the rest of the respondents are to be represented by the council appearing for the General Administration Department, Government of Assam. Mr. A. Fukan, learned counsel, has appeared before this court, submits that he represents the respondents 2, 3, and 4.
2, 3, 4.
He, however, prays for some time. He, however, prays for accommodation for the day, seeking, praying that the matter be listed on some other date. It's taken after 1 week. Mr. P. Bharadwaj appears for the writ petition.
DP of that. My lord, this madam will pass over for time being, my lord. She is on legs. The counsel for the petitioner is on legs.
All right, time being 2 p.m.
Yes, ma'am.
Yes. Affidavit file?
Yes. Only my lord, personal department has filed the affidavit, my lord. Actually, by giving the interpretation of the OMI. And no.
What is being challenged here?
Challenge, my lord, I have challenged the OM itself, my lord, and the exercise, and also.
Which OM? Which OM?
My lord, which memorandum for my lord medical clause 5 of the OM, my lord, for.
Where is the OM?
My lord, at page 53.
Yes. Why have you challenged it?
My lord, because by this OM, my lord, the reservation of the PWD, my lord, has been treated as a reservation of as my lord, vertical reservation, though it's a reservation of horizontal reservation. And my lord, by giving the word interpretation of the word verification, my lord, the person says that it also encompasses to reassess the disability of the PWD, my lord, as reflected in the certificate. Even, my lord, honorable apex.
No, but it is treated as a horizontal. Come to page number 55, clause 9.
No, but my lord, there is the if your lordship kindly see the main only difference between the horizontal and vertical, that has been, my lord, the tempered, my lord. That is clause 4.2.
4.2.
Yes. Person with benchmark disabilities selected without relaxed standard along with other candidates will not be adjusted against the reserved share of post. The reserved post will be filled up separately from amongst the eligible candidates with benchmark disability, which will thus comprise of candidates with benchmark disabilities who are lower in merit than the last candidate in the merit list, but others not selected. This is the difference between the horizontal and vertical.
What is relaxed standards?
My lord, because this is a in direct recruitment, my lord, in Assam, my lord, there is a structure has been framed, my lord, in which structure, my lord, the the object of the PWD of 2016 as also the 1995 Act has been wiped out, my lord. And I have to argue on the structure of the direct recruitment system in the grade 10, grade 4, my lord. Because this standard, relaxed standard, it relaxed standard, they have interpreted many meaning in the OM, my lord. But this standard, which they speak, my lord, it has to read along with the rule, my lord, by the direct recruitment rule, grade 10,
What
grade.
is the meaning? How do you understand? How do you interpret this clause 4.2?
Relaxed standard. It may the persons who have submitted application without claiming he is a PWD category. That is one meaning. And other meaning is he submitted as a PWD category, but he does not avail the benefit of the PWD Act 2016. My lord, this realization cannot be a standard if a candidate apply for direct recruitment not under the quota of PWD, then he will not be eligible for direct recruitment. Because there is a eligibility for direct recruitment, so he must be a sound health, both in physical and mental, and he does not have a organic defect. My lord. This is the eligibility for direct recruitment. My lord.
Where is the advertisement?
Advertisement, my lord. At page, my lord, 38.
8?
38.
38.
My.
Yeah. Where is that clause to say he must be of sound mind?
My lord, under the rule, my lord. 2022 direct recruitment.
In the advertisement, it is not mentioned.
Terms and condition governed by the, my lord, rule 22, my lord, direct recruitment, my lord, at page 38, my lord, if you are to kindly see, my lord, clause 8, selection procedure. There shall be two post-selection procedures. The scheme of examination shall be strictly as per the Assam direct recruitment for class 3 and class 4 analogous post rule 2022 as amended from 2022 and further school evaluation. And then, my lord, kindly see page 9, subclause 4. Preparation of merit list and appointment shall be made strictly in adherence to the relevant provisions of the Assam direct recruitment class 3 2022. If your lordship kindly see the rule, even there are two eligibility for appointment and the application, my lord.
Yeah.
Before my lord studying, my lord, there is a similar case has been dismissed by a coordinate bench, my lord. That was made appeal, my lord, and thereafter, my lord, a review is pending, my lord. And that judgment is the parentorium judgment.
Where is that order?
My order. There is a, my lord, systematic discrimination. Systemic discrimination. And after my lord examination, my lord, only in grade 3, one person has been appointed, PWD candidate, whereas there is a benchmark for the appropriate government, 4% has to be appointed in the total vacancy. And in grade 4, my lord, only 2% has been appointed.
Yes, Mr. Chaudhary, what do you say?
Lordship, here I am appearing for respondent number 5, State Level Recruitment Commission. Lordship, here our part is, our role is that, Lordship, the department gives us the vacancy position. On the basis of that, we make the selection, and as per the criteria, we recommend the provisional recommendation to of the names to the department. And thereafter, as per their qualification and reservation, as given at the time of application, the department, various department verifies them, and accordingly, appointment orders are letters are issued by the concerned department, Lordship. Our role is only limited, Lordship. And the second review of the medical board, that was done on the basis of the personal department OM by the health department. Lordship.
In the rule, my
And
lord,
Your prayer, what is your prayer? It's only for setting aside the review medical opinion.
my lord, and also the OM, my lord.
Where is that? Come to your prayers at page number
Yes,
30.
A, my lord, opinion, my lord. Then B, my lord, certificate shall be issued to acquire the office memorandum latest transfer relates to the derivation, revision, or acceleration of eligibility under clause 5.
And who's for the, which department is it? Personnel.
Personal department.
Who represents? Huh?
We have already filed affidavit here.
Uh,
That's why I was ready for you. Lordship, kindly for timely, my lord, Lordship, kindly see page 53.
Oh,
Page, read petition, my lord.
53.
Read petition, page 53. This is the office memorandum they are challenging. The office memorandum dated 21st May 2022. Annex 14.
Yes.
Reservation were posed for persons with benchmark disabilities and other concessions. And these are the, my lord, page 54, 11 portion, Lordship, Kali, certificate of disability. Serial number 5. A person who wants to avail the benefits of reservation will have to submit a certificate of disability issued by the competent authority. Such certificate, in the event of selection of such person for the post, will be subject to such a verification, re-verification, as will be decided by the competent authority. So, what is wrong, Malad, here? He obtained a certificate. That is to be at a time of verification, at time of appointment, that is to be re-verified and verified. This is the authority has right. The medical board has right to, Malad, see whether their certificate is genuine or not, Malad. And also they up to the benchmark, 40% or above or below 40%. In some cases, we have found that, Malad, so after verification, they have found only 15%, 10% disability. They are not able, eligible. There's a matter is needed to be, Malad, hard.
All right, we'll keep it. We'll you are agreed by this clause 5.
Yes, because my lord, it has given the retrospective effect, my lord. My I was subject to a rigorous assessment at the time of issuance of certificate, my lord. And that certificate is there is a provision for appeal. There is no provision for review. But in the 1995 Act, there is a provision for review. And my lord, only apex court has that after it accepts medical examination is not permissible, my lord. It's a barrier.
This is only a question of verification or re-verification.
Yes.
Yes, the verification does not mean the reassessment.
Huh.
There is a provision for medical examination also, my lord.
Where is that?
My lord, clause 12, my lord. Clause 12. As per rule 10 of the fundamental rules, every new entrant of government service on weapon is required to provide a medical certificate fitness issued by the competent authority. In case of medical examination of a person with benchmark disability for appointment to a post identified as suitable to be held by a person suffering from a particular kind of disability, the concerned medical officer or board shall be informed beforehand that the post is identified suitable to be held by person with benchmark disabilities of the relevant category, and the candidate shall then be examined medically, keeping this fact in view.
What is wrong?
Well, this is medication for that purpose, not to set aside the candidate on the percentage, my lord. Even in the act, my lord,
If it is found they are not qualified,
Even-
if they false certificate, why my lord, government will appoint them?
even my
That
lord,
is the provision, my lord, to a protection. This is a protection, my lord, to the genuine person. So genuine person should get this job.
reservation for my lord for PWD and the
Oh,
4%.
but let us say this on the face of it is available. How are you prejudiced? Are you saying that this is contrary to the PWD Act?
Yes. Misconstruction of the provisions of the whole scheme, my lord. Not a single provision, my lord.
Government can, my lord,
And my lord, kindly,
policy decision, government can
kindly
take
see
in.
another thing, my lord. The in structure, my lord. My lord, in OM, my lord, in supersession of the earlier OM, my lord, 7/1/2019. This OM was settled, my lord. Now the fresh selection process has been initiated under the that OM, my lord, because this OM has been challenged in the
Yes.
in substitution, my lord. The new phrase this is going on, my lord. This OM has been, because this present OM says that the reservation against the post, but the reservation against the vacancy.
Who has filed a review against which order?
My lord, I have
This
just committed-
WPC 3015.
Yes, my
Who has
and
filed a review?
I have,
You have filed a review.
and there is a 6 review, my lord,
Uh,
and actually at the honorable division bench, my lord, it was hard at length, my lord. That says that the
so review petition, the only outcome would be either review allowed or dismissed. If it is allowed,
my lord, that is the one par infinitum judgment. If your lordship
why is
only-
it par infinitum?
my lord, because that my lord judgment, my lord, was not considered the provisions of the RPWD Act 2016. Oh, and only based on the judgment on honorable apex court, which was passed in reference to the my lord 1995 Act.
When is the review fixed?
My lord,
Your
Review
review is
petition.
listed on which date?
not fixed, my
Not fixed.
lord. And honorable judge is sitting in division bench.
We'll examine it. On 20. Day after tomorrow, let us see. We bring out all the facts. We'll examine these matters.
Yes.
These
Well,
matters be
when-
listed
when-
on 20. 20. Mark. Get the name to full stop. Let's
Public.
prayer made by the council for respondent 1 and 2, not objected to by the council. It's up to 4 weeks.
That may be fixed.
Let him come up with some information.
I'm obliged.
Could my name be reflected on the post which administrator?
Names of all councils get reflected in the cause list by the registry.
I'm obliged.
Yes.
Lord, my learned friend is appearing for the FCA.
Yes.
Yes, man,
Allowed.
maybe rest.
Why the delay? Why the delay?
Lord, delay, in fact, if your lordship
Where have
look
you
at the
explained?
explanation at paragraph, my lord,
3.
paragraph 3, my lord.
Heard Mr. S. Dr. and senior counsel assisted by Mr. S. Dr. the applicant. And Mr.
S.K. Chakraborty.
S.K. Chakraborty appearing for the party. And this IA has been filed seeking restoration, recall and restoration. Recall of the order dated. Where is the order?
Page 10. 10. Page 10.
Page 10. Lordship will find it page 12.
One is condonation of delay.
Yes.
So there are two IAs.
Two I.
I have received only one document. No.
Since you have no objection
No,
for
my yes,
restoration, we presume that you have no objection. For
No,
the
no,
delay.
yes, my lord.
All right. This IA has filed seeking condonation of the delay of 279 days that had occurred in filing the restoration application for restoration of WPC. Both 4379 of 2012 which was dismissed for non-prosecution on 18/1/2024 by Board Network. Counsel for the applicant submit that the matter was called up on 18/1/2024 and subsequently dismissed for non-prosecution. So the counsel could not appear in the court and the order of dismissal was not known to the petitioner. So subsequently, upon inquiries made, it came to the counsel came to be made aware that the writ petition was called up and dismissed for default. Thereafter, this application for restoration has been applied. As such, in view of the explanations furnished in para 3 of the IA, there was a delay which had occurred for 7-9 days in filing the accompanying restoration. Para counsel for the respondent does not object with their being. So, considering the submission that explanations furnished by the counsel for the applicant, this court is of the view that the applicant has sufficiently explained the reasons for the delay in filing the IA for seeking restoration of the writ petition, which came to be dismissed for non-prosecution by the order dated 20. Considering all of the above, the IA stands allowed. The delay of 79 days is concluded. 79 days that occurred in filing the this case number 89 stands concluded. IA accordingly stands allowed and disposed of. In the Miss case 89, you write in view of the order passed today in the I, condoning the delay of 79 days, this case has been taken up. It's having been listed is also taken up. The counsel for the respondent submits that there is no objection for the prayer made for restoration of the writ petition, which came to be dismissed non-prosecution by the order dated 12 past WPC. Having perused the grounds stated in the I, in the case, this court is of the view that the grounds have been sufficient, grounds for recalling have been sufficiently explained. And this court therefore consider, and in the absence of any objection raised by the respondent, the party this FMS case is also allowed. The order dated 18/1/2024 passed in WPC number 4379 of 2012. As I stand allowed, restored to 5. What is the matter about?
My
Writ
lord,
petition?
it's a matter where reversion, after the penalty of reversion was chilling. Now, my lord, the person has acquired his legal heirs before your lordship.
Person has?
Legal heirs before your lordship to get their financial, if they win in the case, lord, regarding financial benefit, if any.
You have legal heirs have already been implemented.
Yes, it-
Brought into
yes, yes, my lord.
record.
They have been brought on record.
All right, since accordingly this writ petition stands restored to 5, considering that the matter pertains to the year 2012, let the matter be listed for admission hearing on 3rd of April.
Much obliged.
In the writ petition, you take in view of the orders passed in IHO and writ petition is restored to 5, and the order dated so dismissing the writ petition for non-prosecution stands called. The matter is directed to be listed on 3rd of April.
Can it be on 4th, my lord? 4th, we have some difficulty.
8th,
Yes,
8th of April.
It, my lord, I'll be away from Guwahati. Any day after 18.
No, let it be on 3rd. Or we
Third,
have it on
third,
1st.
third or fourth.
third we have some.
First.
Oh, yes.
1st of April.
All right. Obliged.
Copy of this order be brought to the book. Alage? Yeah.
Lordship, here we were supposed to file an affidavit. The instruction received is not sufficient. We have sought for some clarification. Lordship, either by today or tomorrow we will receive it. Lordship, just a week's time. Lordship may take it up next.
No,
next
this
weekend.
week only, this week only fix the matter, my lord.
Is
Next
he
week.
receiving subsistence allowance?
Yes, my lord.
Then we'll have it after weeks. List this matter again on 10th of April.
10th of April. 10th.
Yes, 10th of April, by which time the respondents may file their counter affidavit or produce relevant records before this court as to why the suspension ordered with respect of the writ petitioner by the impugned order dated 9th of October 2024 has not been reviewed. Whether has it been extended?
No, my lord, nothing. No notice has been issued till now for review and nothing, my lord. That's why, my lord. And it's been this is the 5th time they are taking time for filing affidavit, my lord.
Lordship, if it
After
is
that
not
9th of
reviewed,
October,
Lordship, that clarification, if it is not reviewed, Lordship, automatically it will go, Lordship.
it will go away instead.
Then get it.
Yes, my lord. That's it.
That's why, Lordship, I may take it up next week, Lordship.
All right, next week. Matter be listed again on 26th of March.
My lord, can it be on 27th?
27th. All
Yes.
right, 27th of March. 27th of March.
Highly apply.
Permitting the respondents to complete their inspections in this regard.
Right.
About 6:30 to 27th. It is yes.
The suspension was beyond 90 days, they have issued that. They have filed an affidavit, my lord.
In the affidavit, they have also admitted it was filed after 90 days, my lord. The reason they have given something else, my lord, but that will not do, my lord. The specific case is,
Page, paragraph number?
yes, paragraph, your lordship, 30, page 35. There is a response, my lord. Page 35. Today they filed them.
Yes.
Further, your lordship, further, the deponent state that the delay caused in issuing so-called letter is due to non-receipt of any written communication from the Vigilance Anti-Corruption Assam, as well as from the petitioner as regards the release of the petitioner from the police custody. Of late, the office of the deponent came to know that the petitioner has been released from police custody in the meantime. The suspension order was already reviewed in the meantime on 13/12/24, and second review will be undertaken before the completion of another 90.
So when did you inform them that you were?
I did not know because they know it, my lord, because they are placed under suspension order. Also, kindly the letter itself will show. Suspension letter. Suspension letter, you also will find page 22. Page 22.
22.
Yes.
Yes.
This is order dated 18/6/24. Whereas an intimation has been received from Sri so-and-so, so-and-so, so-and-so directors or by data number so-and-so regarding arrest of the present petitioner.
Yes.
Arrest of the present petitioner in connection with the case number so-and-so. Whereas no further communication has been received from any corner till date regarding release of Sri Shamayat Bhattacharya DDA from custody of the so-and-so after expiry of more than 48 hours from the date and time of his arrest. In B of the above and as per Rule 2 of 6, Assam Service Discipline Rule, so-and-so is deemed to have been placed under suspension with effect from the date of his arrest on 12/6/24. With effect from 12 is the date of arrest, man. Now they are to say from the date of arrest, not from the date of release.
No, there is a judgment of a coordinate bench of this court.
Yes.
That you have to intimate them the time
But
you
it
release.
is within their knowledge, man. Within their knowledge.
No. There is an order of this court. There is a judgment of this court.
That is but what they have said, madam. What they have stated here, that because I have the anti-corruption department also not informed them, as well as the petitioner, both they have taken.
Maybe. There is a judgment, must be aware of that judgment.
That is my aware, my lord.
That judgment has laid down certain criteria as of date, since this is holding the field.
So that we have to check, madam. Then in that case, we have to file reply to that point.
Then you have to
reply to that.
Because that judgment says that you will have to, because the judgment seeks to resolve the lacuna which is there under the rules. If you see the CCA's rules,
yes,
there is a provision that this 90 days will start from the day he is released and intimation is given.
Yes, but law is very clear. Office memorandum as well as my lord Ajay Chaudhary, that is clear for the date of arrest.
No date of arrest, but
my memorandum is the office memorandum. The yellow kind is a page. Page is there, my lord.
Page number?
Page number 467. 467. If this is the book, my lord.
467.
467. Yes. If this is the book, my lord.
I think this is the book, yes.
Yes. Page 467, bottom. 2.1.8.
467, bottom.
Yeah, bottom.
Yeah.
The following principles and procedure with regard to suspension need strict compliance.
This is all right, but
suspension should be resorted there. Two, my lord. Command two.
But you'll have to interpret. You'll have to distinguish the judgment.
No, that of course. But what the law, their own memorandum says, my lord, it says from the date of suspension, failing which government servants concerned should be reinstated. Very categorically it was taken. And in terms of Ajay Chaudhary, as well as latest other one is my lord Sanwal, Ajay Sanwal case. This is all interpreted in that way by the mandatory matter.
Deepak Mali.
Deepak Mali also there and Sonwal also there. That is mentioned here in Deepak.
Therefore, you will have to aggress on the judgment of this court.
That's true. That is there, my lord. But ultimately, what I am going to say, my lord, that is the
There
law.
is no point having different judgments by the same court. Judgment must be
Distinguished in that way.
there must be one judgment, one direction from the court in respect of one matter, one set of matter.
Paragraph 13, your lordship.
Yes.
Paragraph 13. Copy 9. And so,
But the fact remains, it is para 13 with is just thinking aloud. You see, ultimately the department is bound by a set of rules. Unless the rules are put to challenge or the court interprets the rule to be in conflict with the decision of the apex court, the first priority would be the rules.
So rules is there, my rules.
There is no indication.
No, so official memorandum also in terms of that matter, they have prescribed the rule. Their official memorandum, they have issued it.
Now, apex court judgment will have to be understood in terms of the rules.
So, but rule says also, it does not say about 3 months. Rule says it may be reviewed from time to time.
Which is why the judgment of the coordinate bench is relevant here.
So that's why, my lord, I think that needs to be, yeah.
That judgment has laid out that from the date of release, 90 days.
Yes. So we have to see, my lord, that also. So in that case, my lord, that reply to the affidavit that will be made.
All right.
But they have not stated on the date of release, matter. They have simply stated, I have not informed. That much, matter.
Yes. WVC 4552023.
But there is also an office memorandum.
Yes, Lord. So I
So
will
that
come
is to be seen,
and
madam.
I will
Which one
come
prevail?
to that point, Lord.
That office memorandum.
Let us first.
Which one will prevail?
Is it available here?
The other one.
Office memorandum? Subsequent one?
No, subsequent, it is, your lordship is mentioned in other case. The coordinate bench passed the order on the basis of that subsequent.
No. Coordinate bench had passed an order.
2020 office memorandum is there, Lord.
But subsequent to that, there is an office memorandum.
Yes, Lord.
So that is not there, madam.
No, but first they have to achieve the this Rafael Hussein, and then only we will go to that point, that limb of argument.
Heard Mr. H.R.A. Chaudhary, counsel assisted by Mr. H.M.R. Khan. Chaudhary. The respondents represented by Mr. J.K. Goswami submits that an affidavit to be responded a bit fine. Stop. The counsel appearing to the petitioner submits that in view of the reply affidavit file, they may be permitted to file reply affidavit. Sorry, in view of the affidavit in opposition file by the respondent, they may be permitted to file reply affidavit if so advised. Accordingly, prayer for 2 weeks time.
1 week, madam. I will file by this Friday, madam.
He submits that the reply affidavit, if required, can be filed within 1 week.
And next week, madam,
let the matter be listed after 1 week.
After date, madam, only date. Otherwise, he is in trouble. My suspended allowance also is not given. Full.
4th of April.
4th of April. Yeah. Obliged to.
The pleading is complete, my lord. You can pick it for admission hearing. This is regarding family pension by second wife.
Family pension by second wife.
First wife is not there. She expired, lordship.
Ah.
Thereafter, second, petitioner has come into picture.
They entered into marriage during the subsistence of the first marriage.
Yes, but first wife is not there, Lordship. She expired in the meantime. And Lordship, she's claiming only pension.
No. Person, your husband
Lordship.
had one wife.
Yes,
First
Lordship.
wife.
Lordship. But after expiry of first wife,
When?
they were living together, Lordship.
When?
Lordship.
During his tenure, after his expiry.
Living, Lordship, since, I mean, long back.
But that
is there.
doesn't speak to marriage.
No, that is their Lordship, but there is an affidavit, husband of the petitioner, Lordship, saying that I'm Lordship. Within the page number 23, Lordship, annexures 6.
Council submits. Council for the parties submit that the pleadings are completed and to be they submit and an attempt be made to dispose of the matter at the admission stage. The matter be listed on 29th of April for admission.
Please, Your Lordship. Chief, we have filed our reply affidavit today, Your Lordship, in the morning. So matter may be taken up on 19th or 20th, Your Lordship.
It is submitted that the reply affidavit has been filed during the course of the day. The same, however, is not connected to the case record. Registry will trace out the affidavit stated, reply affidavit stated to have been filed with the petitioner and connect it to the case record, and the matter be listed thereafter, the month of May. What is the matter about?
Lordship, matter relates to petitioner has filed, Lordship, this writ petition for setting aside the speaking order, Your Lordship, that was passed by the respondent number 3, Your Lordship, and seeking a direction to grant the minimum pay scale to the petitioner with terms.
Yes, Mr. Botagur, have you received a copy of the affidavit?
We have not received it.
List on 29th of April.
Lordship, on 20th of March.
Right? No. Not 28th of March, 29th of April.
Like,
Lordship, I can remove 49, Lordship. 29th, I have some personal difficulty. Can it be slightly earlier? I will inform Mr. Bora.
Then it will differ. It will go to May. We can have it on 1st of May.
Lordship.
1st of May. Please inform Mr. Bora.
Please, I.
Now, my lord, this OM is the personal department which has been upheld by
No,
this.
no, please go and see the last order. See the last order. Get into the habit of checking out court records to find out what orders were passed. First, office notes are there. You go through it just after a few minutes. Go to the last order. तो फाइल दे दीजिए ऑर्डर देखने के लिए. Yeah.
On the last day, I elaborately placed my argument. My case is of punishment transfer without affording me any opportunity of being heard or any inquiry. That is, therefore, the transfer order itself is illegal. As per law settled, I have already submitted decision of Honorable Supreme Court to Sumesh Tiwari versus Union of India.
Yes, Mr. Bhatto, is that
But Lord, Sumesh Tiwari case, my lord, I have gone through, my lord. The facts of the case is not exactly similar, my lord. In that case, my lord, they have conducted an inquiry, my lord. In that inquiry, nothing was there. Thereafter, the inquiry committee recommended the transfer, my lord. And the case was mainly for the recovery of for
No, but
non-payment.
here you have imposed a punishment.
My
Without
lord,
conducting it and giving it opportunity.
my lord, although that was reflected in the deputy commissioner's affidavit, my lord, but the actual thing was some complaint was admittedly received. That was, as the deputy commissioner is not the appointing authority of the petitioner, those were submitted to the commissioner, my lord. The deputy commissioner on routine basis transferred, my lord.
No,
Because
his affidavit doesn't say so.
the affidavit, that is, I am saying, my lord.
We go by the affidavit file.
That is.
What has happened to the inquiry instituted? What has happened to the inquiry?
Inquiry, that part, in this case, my lord, that instruction not received, my lord.
What is the status of the inquiry?
That is also not there, my lord.
Then what remains?
Because in lordship, in Ajay Chaudhary case also, my lord, if after 90 days for reinstatement, he can be transferred to another place, my lord.
You can be transferred.
Yes,
Nobody
my
is questioning the power of transfer, but you are transferring him on punishment.
My
So
lord.
if you want to impose a punishment, then you have to give him a opportunity.
I don't know, my lord, on what basis they have.
If you don't know, who will know? You are the
The deputy
counsel
commissioner, I am
representing the
taking about
respondent.
deputy commissioner's affidavit, my lord.
No, so who represents the deputy commissioner?
My colleague was there, I don't know.
But where is your colleague?
Football, sir. Goswami. Otherwise, if that paragraph was not there, my lord, this case is not applicable for the present case.
At least we have to
yes, my lord.
Acknowledge the fairness of the DC that he has been able to put it in an affidavit.
My lord, I understand that, my lord.
And
Because he cannot take any action against the petitioner.
all right, we're keeping it for Thursday for orders.
It's that can be
Thursday.
my lord.
List on Thursday for admission. An attempt will be made to dispose of the writ petition on the next date fixed.
I love this.
Yes. Have you seen the order? Yes. Then
Government advocate will have to clarify, my lord, from the record.
so you are representing whom?
I am representing PH, my lord.
So where is the government advocate?
My lord, on the submission of PhD Standing Council, my lord, the Honorable Court recorded the statement that the DLC considered and accordingly it was referred to the SLG. As per his instruction, my lord, this Standing Council of
All right,
PhD.
we'll have it on Thursday.
Yes.
Thursday.
Thursday.
Heard learned counsel for the parties by earlier order dated 24/2/2025. The learned government advocate presently was directed to, was permitted to clarify, was permitted to clarify the stand of the department as to whether the DLC had indeed considered the proposal of the writ petitioner and forwarded it to the SLC, as was recorded in the order dated 29/1/2025, or whether the same was not considered by the DLC, as had been communicated to the government advocate by the department by communication dated 7/2/2025. Stop. Matter was fixed today. Stop. However, none represents the government council. None represents the which department is it?
PhD, my lord.
PH, I am there, my lord. For DLC and SLC.
For SLC.
Respondent number 2. Respondent number 2 and 3. Stop. Accordingly, this court purely for the ends of justice matter is deferred to be listed again on 2020 on which date the government council who had, the government council will apprise the court in terms of the direction contained in the order dated 24/2/2025 and the order passed to the stop. Let a copy of this order be marked to the office of the senior government advocate for doing the needful.
My lord, PAC Department Standing Council, we will also place the
Mr.
materials,
Potapur, representing the PHA department, will also place all necessary
the DLC.
matters before this court.
Yeah.
Relevant facts and records necessary before this court. Based on 20.
Yes.
Alright. Alien. Yes.
May may I please your lordship, my lord? In this matter, my lord, I am released on interim. I am on interim bail, my lord. And as per direction of this honorable court, I appear before the learned trial court, my lord. And trial court, I was allowed to go on regular bail, my lord. That is the your lordship. And
You have been allowed to go on regular bail.
yes, my lord.
Huh.
Because, my lord, here is the direction that he shall appear before the court, CGM Borpeta. I appear. Thereafter, my lord, copy has been served to me, my lord. A matter, sorry, my lord, matter has been fixed for appearance, my lord. But one accused person, key naam sila?
No, but if you are on regular bail, then what is the point in this?
Because, my lord, on the basis of this interim order, I was on regular. Your lord, made this bail application.
Which is that interim order?
Your lord, kindly 3/8/2023.
3/8.
3/8/23.
Yes.
Otherwise, my lord, in the charge sheet, he was shown as absconder. One person was killed, my lord. And as per status report, latest status report, office note dated, my lord, 15/5/25, my lord, may kindly see the flag D. In the main file itself, my lord. Main file itself, flag D.
Hey, niche wala.
No, not in the LCR, my lord, main file, my lord.
Main file.
Main file, flag D, my lord. Flag D. Latest instructions, my lord, status report up to, my lord, 11/2/25. No charge were framed, as one person is still absconding, my lord. Now,
Not this person.
not this person, not this person, one another person. Earlier, my lord, in the charge sheet, several persons were shown as absconder. He is one of those persons. Subsequently, after the instruction of interim order of this honorable court, my lord,
Is
he has
there any
appeared.
other material to show that he has influence?
My lord, one fact, my lord, actually, I have not gone through the whole, my lord, because of this.
Please go through it.
And earlier, one notice there, my lord, several witnesses are there, and some implications maybe, my lord. I have to go thoroughly, my lord. Because of this, my lord, I have not yet actually, my lord.
May I submit, my lord?
Yeah.
Yes, Lord. Lordship,
No,
can
let him go to the record.
Yes, my lord. My humble submission before your lordship is that, my lord, my lord, there is a several accused person. All are released on
So we
bail.
are not on that. We are asking
Yes,
him
my lord.
whether there is any
My
material.
humble submission, one of the accused persons, my lord, in this case, my lord, earlier when the bail application was rejected, by concealing these facts, has got the, my lord, interim, and that bail matter has been made absolute. I pray your lordship one decision. If your lordship go to this, my lord, my case is much better than this person's case, my lord, who is released on bail. In my cases, I have gone to the my lord, whole charge sheet, my lord. Content of the charge sheet, nothing has been said against me, my lord. Only, my lord, column of the accused person, my name has been shown, my lord.
That is all right. Therefore, we are giving you interim protection.
Yes.
And when can you go through it?
My lord, the day after tomorrow can be fixed, my lord.
Can you fix, my lord, after Bihu?
Then
After Bihu. He is ready for day after tomorrow.
Yes.
You are not available.
I am.
Wednesday, Thursday, any Thursday.
27, my lord.
27, all right. 27. 27th of part. Heard Mr. Hiren
Again,
Chaudhary learned.
27 again, I may not be there, matlab, other APP may be, matlab, APP.
Hiren Chaudhary learned counsel for the petitioner, Mr. K.K. Porakar, learned APP appearing for the respondent, MS Yangtan appearing for private respondent. The learned APP seeks accommodation to peruse all the relevant materials available with him and before the court, including the up-to-date status of the case pending before the trial court, which has been called for. Stop. As agreed to by the learned counsel for the parties, matter is directed to be listed again on 27th.
Matlab, may I matlab, 1st of April, matlab, then second,
1st of April,
1st of April, Tuesday.
Can it be second?
Six,
Seven, my lord.
not 7th.
7 Monday.
Give us. All right, it can be on 7th. 7th, you want it on 7th of April.
Yes, my lord.
All right, 7th of April. Please take order.
Hmm.
Met with lots of power. The CRPA constable, my lord, dismissal of service. There are twice the same incidents happened, my lord. Drunken state lying on the duty post with arms thrown around. But in that minor punishment was given. In the second one, my lord, he was dismissed from service. Now, my lord, I have seen the, without recording, my lords may not record my statement, my lord. Anyway, I have seen the person's condition. He is so much alcoholic, to be candid. My lord, he is not in position to join the service and continue for another 15 years. Because 55 is the retirement age of the CRPF. So he is only 40 now. 40, he was 40 in 2019, now he is 45 or 46. So, my lord, what I want is to be shortcut. My lord, that he has some PF to be give it to him because it is personal money. His contribution is also there. And my lord, gratuity and any other benefit and the certificates, origin certificate, his qualification certificate, everything, and including his OBC certificate because lack of OBC certificate which is attached by them, my son cannot get the OBC and he is not getting admission in school. This, so these two things you will also may dispose of.
Yes, Mr. Porakar.
Because otherwise, he is not in position to.
Otherwise, yes, matlab. But regarding these documents, these are the not in the pair, matlab may consider under 226.
Now,
Otherwise,
this is recently I got the
No,
instruction.
no. Question is if the man is dismissed from service, certain documents which are
it
necessary
has to be returned back.
has to be returned back. What
Yes,
for do you want it?
Don't know.
Now
That
you-
things only come.
Just last week I
so
when he
let him get his instructions
yes,
that
yes.
his documents are available on record or not.
must be last week only when he telephoned us that his son couldn't get
That is his instruction.
Yes.
Let him get his instructions from the department. And on that date we'll dispose it of.
Matlab may reflect in the order. Matlab I'll.
And secondly, my lord, that his PF,
PF,
PF and other financial benefits.
Heard Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. P. And also heard Mr. K.K. Porakar, Learned CGC, appearing for the respondent. This petition has been filed by the petitioner, who was at the relevant point in time serving as Constable GD in the 87 Battalion Central Reserve Police Force. Stop. By order dated 31/07/2018, petitioner was dismissed from service by the Commandant, 87 Battalion CRPF. Stop. Pursuant thereto, the appeal filed by the petitioner also came to be dismissed by the appellate authority by order dated
On 16/10/2020.
no 27/8. On which
No,
date was the appeal dismissed?
16/10/2018.
16/10/2008. So these two orders are put to challenge in the present writ petition.
In addition, my
And
lord, that
seeking reinstatement in service along with all service benefits. So the respondents have pleadings have been completed in
Yes,
the matter. So today when the matter is called up, the counsel for the petitioner, senior counsel for the petitioner, submits on instructions
Yeah.
that the petitioner does not wish to press the writ petition any further, challenging the
no, ma,
impugned order.
then might not be recorded, my lord. Simply, your lordship now let them get instruction on these 2 points. One, financial benefits, GP.
submits that the petitioner's PF dues and other relevant documents, including his OBC certificate, have not been released have not been handed over.
Vision, other qualification certificate, everything.
All relevant documents, including his credentials and OBC certificate, which was submitted at the time of entry into service, have not been released, because of which petitioner is facing difficulties in seeking admission
Of his son.
of his son, proper admission in educational institution for his son. So, Mr. Porakor will obtain required instructions as to whether these documents are available to be released to the petitioner as prayed for, including his PF dues.
PF and other financial dues.
PF and other financial. So, let this matter be listed again on
The first week of April, any date, my lord.
4th of April,
My lord. Four, my lord, fourth one.
7th of April,
My lord.
7th of April.
Available.